Your lordship sleep mentioning one matter for upgradation with notice.
What is your urgency?
Urgency is, my lord, the petitioner is aged about 85 years. Her land has been taken, but without any compensation.
Give them.
Well, I am mentioning that matter which was virtually completed hearing.
Yes.
And matter was directed to be listed today for orders or something like that.
Yes.
Well, I find today the matter has gone in the listed motion. So, my lord, unless it is being taken up tomorrow, I will be out of station for the next week. So, my lord, let it appear, and that is your lordship will remember.
Upon notice.
I have given notice. Upon notice, obviously, I have learned that without notice, my lord not to accept. I have given notice.
For orders ছিল তো এটা বলা দেখে নিন কালকে ফর অর্ডারস রেখে দিন তাহলে আমাকে একটু দেখিয়ে নেবেন আমাকে একটু দেখিয়ে নেবেন
Let it be at the top so that it can be taken up tomorrow.
থেকে বলবে তো উনি আপনার থেকে অনেক সিনিয়র দেখলেন না
ঠিক আছে
নয়ন আছে
না আপনি করবেন না আপনি নিজে বলছেন কি ঠিক আছে তাহলে আপনাকে আগে বলতে না আপনি বললে আগে বলতে দিতে হবে
my lord on 22nd November 2023 matter was heard matter was appeared and your lordship fixed on 17 January 2024 but anyhow the court was not set. My lord, the matter is appearing, my lord, now item number 863 for hearing. My lord, kindly fix it for any day.
Are you mentioning upon notice?
Yes.
My lord, I had mentioned these matters yesterday, two matters 851 and 860. Lordship upon being with this taken resumed by the government. The lordship had earlier updated it both.
On notice?
Now I've served notice, my lord. This is not here because I've served by email. Both of them, my lord, if your lordship kindly, my lord, update them. Well, may I hand it over?
Hearing matter.
Your lordship, this matter is for upgradation.
Upgrade. Yeah, notice দেওয়া আছে। হ্যাঁ লেখা আছে সব পাশে তলায় সব লেখা আছে এক মিনিট
নীল ওটা আগেই ছিল পড়ে ছিল ওটা fairly at the top
Lordship, I'm deeply obliged.
Hearing heading এ থাকবে fairly
Upgradation with notice.
hearing heading এ থাকবে fairly at the top
Your lordship, this
give
matter
a minute
for
just একটু কাজ করছি
কোনটা ওইটা
এটা mention matter এর উপর দিকে
My lord, may I permit to mention for upgradation upon notice?
Yes, madam, please. Yes.
application for upgradation matter is relating to payment of compensation
You are mentioning upon notice?
notice.
your lordship, this matter is for upgradation with notice.
My lord, he is my raw junior.
Your urgency?
Urgency is, my lord, private respondent.
Let him
Yeah,
pick.
to him, boss.
Private respondents are obstructing egress in ingress.
Give them.
My lord, may I permit to mention for upgradation upon notice? Petitioner applied for the land user certificate, but authority rejected. Other hand, the similar circumstances, other person get land user certificate from the same authority, my lord.
Upon notice?
Upon notice, my lord.
Lordship, may I be permitted to mention two matters for upgradation? It's upon notice, Lordship. The respondent authorities, they are contemplating land acquisition on the owned shop rooms of the petitioners, Lordship.
Give the number, let me see.
My lord, this is application. Earlier disposals of the matter of it lordship directing the district and land reforms officer to deliver position of the water body. Then some person, they are not petitioner, they are filed appeal. Matter number 419 and 23. Their lordship has gone to the matters and two orders I have annexed.
What are you?
And dispose of this matter. So
It is disposed of already.
then some other persons they file in matters.
Matt, so this how will this court deal with it? This court cannot deal with mat suits. Mats.
Appeal.
This court can deal with appeals.
Yes, ma'am.
This court can deal with appeals.
ডিভিশন বেঞ্চের করেছে।
I'm not able to follow you, madam.
Again, deliver the matter. This, kindly see the order, madam.
Show me the order, please. Remand হয়েছে নাকি?
রিমান্ড করেছিল তাই বলতে পারছি না ওটা বলতে হবে তো।
You're mentioning upon notice to the other side?
My lord,
Item number 66.
Your lordship, may
my lord, may I be permitted to mention, lordship? My lord, this messing for upgradation, lordship, the private respondent constructed unauthorized construction.
Upon notice?
Upon notice, lordship.
My lord, your lordship, may I take your lordship's kind leave to mention one matter, your lordship? Your lordship, this is my petition challenging one resumption order dated 22nd of December 2021. Your lordship, this matter was listed on 5th of January 2024, where your lordship was ready to hear up the matter. But your lordship, as a interim order got expired on 30th of September 2023, your lordship had directed us to file an application for extension of the interim order. Your lordship, we have filed that application on 25th of January 2024. Your lordship, this matter was running in the monthly list as to 89 as item number 89 and 90. But
You're
your
asking
lordship,
the application to be heard first?
yes, your lordship, application along with the writ petition, your lordship, both. Your lordship, but it's not.
Notice?
Yes, your lordship.
Give the number.
My lord, may I permission Grateful, for lordship. application? PW Road Authority acquired the land of the petitioner since long back, but no compensation has been paid.
Upon notice?
Yes, my lord. I have.
My lord,
Your lordship, may I be permitted to mention, your lordship, for upgradation, your lordship, the petitioners are suffering for more than 4 years, your lordship.
what is your urgency?
Your lordship, the land of the petitioners, your lordship, has been illegally encroached upon by the respondents, and currently, your lordship, unauthorized construction has been going on, your lordship.
You're mentioning upon notice?
Yes, your lordship.
Give the number.
Much of,
Madam, may I be permitted to mention?
Have other matters also to mention? Yes.
much of.
Yes.
Upgradation, private respondent in the instant writ proceeding obstruct free ingress and egress of the petitioner by constructing shop room and house in the front of the petitioner land by acquired government land by
Upon
law.
notice?
Upon notice, my lord.
Madam, may I be permitted to mention? I'm mentioning upon notice, my lord. On due consideration, I bought the property, but without any vesting order, that property was treated as enemy property. I challenged the order before this honorable court. Honorable court, on the previous occasion, Honorable Justice Pradeep Prakash Banerjee, as his lordship then was, he was dealing with the matter. He asked the Home Secretary to take a decision. And my lord had the my lord had the opportunity to hear it on contempt, my lord. I moved this here. On contempt, Home Secretary took an order which went against me. So, challenging that order, I have moved this court. Now, my current urgency is the property, which is a land property, third party interest is created. Are being created. That property is being all the orchards, everything.
Upon notice?
Yes, yes.
Give
This is my
the number. Yes?
Contempt application upon notice.
New content. Give the number. Yes, call the raise list, please.
Item on this matter has already been disposed of on 12th of December.
Already 29th আবার এসেছিল
এই ম্যাটারটা না রে বাবা একটার পর এক কথা বলছি
Why was it mentioned?
এইটা সুপুর একটা এসেছিল না
এটাই
ও এটাই
Why has it been mentioned?
I don't know. Earlier also this matter appeared on 29th of January. And it has been recorded, no order is to be passed. Again, the matter is.
Why is the matter not leaving this court? It's coming back again and again. Can
Oh, report. এটা
Oh, the report submitted by the respondent is recorded, but it's not in the file. Mr. Protocol, please check.
or I recollect the matter is related to short-term mining lease.
Yes, yes.
Mining license of sand. They have submitted the application in August 2023. And
That was directed to be
during the
considered.
course of hearing, it was pointed out that subsequent to the West Bengal sand mining policy, this one came into effect. All application will be dealt with by WPLPCL. Accordingly, WPLPCL was added as ninth respondent, and the application was forwarded to WPLPCL. Decision is on the way. Hearing has already been concluded. Order is yet to be passed. Within 2 or 3.
The first line of the order says report submitted by the respondents is taken on record. Will you please find out? And if it is there with you, please submit the report. Then I can, that's the reason why it's coming back again and again. Shall I make it not to?
After a week,
I'll make it not this week. Let it appear on Monday. Please find out in the meantime. Thank you.
That's
Please give a copy or just keep it in the on record.
I am for the petition.
The matter where your lordship had been. Where your lordship had been pleased to, my lord, direct demarcation to be carried out by HIDCO and the state. On the last occasion, I had, my lord, requested for an adjournment in order to ascertain what is the position. I've sat with the BLN Eralo, my lord, the concerned officer himself, my lord, and also, my lord, with the HIDCO officials. Situation is this, my lord. It's really, my lord, not possible, my lord. And immediately, if your lordship directs, my lord, we will have to do it. We will do it. Otherwise, my lord, there'll be a mistake. What is, my lord, I'll just give your lordship, my lord, the background. This is a dag, my lord, large dag. 3 parts to it. One part is, my lord, the HIDCO's acquired land. Second part is acquired for the purpose of, my lord, a road. Third part is large number of, my lord, private individuals have purchased and are, my lord, in possession of the property. There is no, my lord, free property. Now the petitioner comes forward and says that I have a right and I am entitled to possession of a particular property. So, my lord, either his land is a part of the land which is, my lord, HIDCO's portion, which has been acquired, or, my lord, a part of the road, or, my lord, his land is private property, where, my lord, one of the vendors to any of these private individuals has also, my lord, sold. Lordship knows what happens in these places. Now, my lord, our solution was that you produce the acquisition maps for the 2 acquisitions, and you also demarcate at least, my lord, notionally where his land is. Then we can tell him that, look, your land is within, my lord, HIDCO's land, or your land is within the road, in which case, my lord, his writ petition will be dismissed, or your land is my lord, private land. So in that case, he'll have to go and file a suit. Now, BLRO says that he doesn't have, my lord, the acquisition maps. He, my lord, wrote to the state government, my lord, till now they have not been able to find it. HIDCO, my lord, on its website has a map. So, my lord, I requested them that when you make a map, it must be on the basis of your acquisition map. They have not been able to trace out the file. Yesterday, my lord, I was supposed to go to the government pleader, who's presently, my lord, broken his leg and he's sitting office. So, my lord, but 115, my lord, I got stuck before a division bench which continued up to 140. I couldn't go. This needs, my lord, it's unfair, my lord, if it's not, my lord, if we must at least be able to tell him where his land is. That is unfair. Then, my lord, it's his rights. Your lordship will decide his rights. But we should tell him, if this is the situation, my lord, this is my lord, report to your lordship. Now, if your lordship, my lord, permits me to go and speak to the government pleader, I'll request him to appear. And with his intervention, my lord, the state government should produce, my lord, the acquisition maps, from which, my lord, we'll be able to give answer to my learned friend. My lord, in all probability, he will not be able to get a physical demarcation, but at least he will know where, my lord, his land is. This, my lord, is the situation.
My learned friend says that what land has been private land or land is the acquired land. That is all the documents lying with the state authority. It is not the private individual. my responsible submission, my client has purchased the land. Land has been mutated by the concerned BLRO, and thereafter position is my land. Suddenly, my land has been, my lord, encroached by the HITCO. That is the case herein. Otherwise, there is no case. When the HITCO come to the encroaching my land, I come before this court that should be demarcated my land, or the produce as to whether my land has been within the acquired position or not. That is demarcation is proceedings going on.
If both the acquired portions are demarcated,
Of course, there
that
is.
solves the issue,
Yes,
isn't it?
but that demarcation will only be evident from the acquisition map
That is the state
at the
authority.
time of land acquisition, which Milord, the BLRO can't find. Milord, two things, Milord, I humbly submit, Milord, may be done. Your Lordship, Milord, may be pleased to pass an order directing, Milord, the state government to produce, Milord, the acquisition maps pertaining to acquisition of land in this Dag. With that order, Milord, I'll request the government pleader, Milord, to take necessary steps.
That is a BLRO is a state authority. BLRO can
Milord,
ask for
Milord, if he,
acquisition proceedings. When
I'm
BLRO
trying to
is the
help him.
immediate authority to demarcate the same. BLRO can, my lord, the approach before the authority to produce the LR in map.
Mr. Chaudhary is trying to help you also.
That is, I understand.
He's trying to find out a solution to this issue.
That is true, my lord. I am not disputing about this. Since my client is present at the time of field inquiry, my client is present.
Milord, his
My responsible
purchase,
submission
his
cannot
purchase
be-
in all probability is ineffective because it will either be, Milord, acquired land or he'll have a private dispute. Two, Milord, possession, he's never been in possession. When there's no proof of possession also. But in any
That is
case,
true.
a citizen, Milord, is entitled to know where his land is. And it is our obligation to, Milord, indicate that to him. Kindly, Milord, permit
Mr.
this.
Bhattabhai?
My lord, the BLRO has wrote 4 letters to the land acquisition department for supplying them the alignment map. The land acquisition department could not be able to supply those.
We sat with the BLRO together.
The direction will given to produce the map. Otherwise, the entire thing cannot be acquired. The plot is a vast area. I am
The
understand.
acquisition map is required,
Required.
both of the HITCO and of the state.
So
If
far,
those parts are segregated, then you
Yes.
get the remaining
Yes.
portion.
If it's within those parts, then Milord, he's bought Milord
I
ineffective title.
Altogether.
I
Yes.
If it's
stand,
Milord
my lord.
private land, he'll go and fight in civil court.
I
He
stand,
should know where the land is
Exactly.
and the quantum thereof.
Exactly.
I
Milord.
stand, my lord, after purchasing my land, the concerned authority, my lord, as per the procedure, my lord, the mutation has been done. As position is been confirmed in my position. Suddenly, the HITCO acquired the
Position doesn't confirm positions.
I was still in position. Suddenly, my lord,
Never in possession.
appreciate.
Acquisition
Kindly
in
appreciate.
95, 96. He's bought in
No,
2016.
suddenly
He's
they
ended up
have-
buying acquired land.
Oh, my lord. When I come before this court, when they have encroached the property, then I come before this court. Dispute arises, rejecting demarcation. That I come before this court. My lord, otherwise, my stand, my lord, purchase
Acquisition was done long back, isn't it?
95, 96.
95, 96
Yes.
acquisition was done.
Yes. My lord, all things will be, my lord, solved. Let them produce the map
Correct.
of the, under the what.
That's right. That's
I
right.
agree with my learned friend.
Of course, I cannot, the entire portion cannot be acquired.
Record, your submission in short, not the
Yes,
entire-
yes, Milord. No difficulty.
My lord, kindly direct the special land acquisition officer to supply the map
Yes.
to the BLRO.
You will produce it in court.
Then, my lord, the only thing, as to whether the
Ashok na.
BLRO asked for, otherwise,
Yes,
special
file
land-
রাখতে
He has asked.
that memo should be referred. That memo should be referred. Since the BLRO asked for,
The
why not provide?
submissions are sufficient, isn't it?
That submission memo should
reference
be
of the-
referred.
It is submitted on behalf of the first alleged contemner, you are one
Yes.
contemner, that the joint demarcation as directed by this court shall not be possible unless the acquisition map of the plot in question is produced by the state authorities. Stop. Learned Counsel for the state respondents also submits that despite several communications made by the block land and land reforms officer to the special land acquisition officer,
Not to
to the special land acquisition officer
Not 24%.
not 24 Parganas, not 24 Parganas, comma, such acquisition map has not been produced, so not been supplied. So it is not in dispute, paragraph, it is not in dispute that the entire plot in question, that a portion of the plot, entire, the portion, a portion of the plot in question has been acquired by the state respondents, comma, another portion acquired by the HIDCO, and the remaining portion belongs to several private individuals.
In fact, my lord,
Paragraph in view of the above,
in fact, my lord, so far my knowledge, several matters I moved before lordships relating to the particular plot in question. Relating the particular plot in question, difficulties arises by the HIDCO encroaching the property and without we having the map. That is the
paragraph in view of the above, this court is inclined to hold that unless the maps with regard to acquisition of the portions of the plot by the state respondents as well as the HIDCO are produced, comma, joint demarcation of the plot is not possible and the portion of plot acquired by the petitioner by virtue of purchase, comma, as submitted on behalf of the petitioner, comma, can also not be identified.
No, my case, my plot is identified, portion is identified by my registered deed of property.
That is,
And that has been mutated.
Physically identified. Registered deed
physically-
says so many things.
Physically was my lord, at the time of registration I got position. That
Please
is
show
my
me one
content.
document of possession.
That is
ROR.
contention in my writ petition also. At the time of registration, I got the position. Subsequently, HIDCO encroached the portion of the property, not entered my land, in portion of the property.
Let
That
the
is
maps
different.
come forward. Let the
Yes,
maps
if
be
your
produced.
lordship, why is the physical inquiry has been done, madam? In the presence of the petitioner and the.
Of course, I
At the time
think
of
that.
inquiry, they could not be able to show which portion of the plot they are, madam.
Even they don't know, my lord.
No, certainly not. This is not the correct. They are, without the having this map of the requisition
Have
acquisition.
you been able to point out which portion of the plot you are occupying,
No.
you have
Let them
purchased?
show, madam, which portion of the
They-
plot.
The petitioner?
If I shows my lord, they will deny. This is
Have
the
you
thing.
shown?
Yes, of course. If that will deny. So entire thing will be decided by not the, my lord, so far my concern, my lord, I can't say, my lord,
Let
several
the
matters I have moved
let
before
the
lord.
maps come forward.
Kishore office থেকে করিয়ে দিন।
And let the notice before the.
May I have my lord's leave? If your lordship keeps it after 2 weeks, my lord, I'll get the needful done.
After 2 weeks.
Yes, my lord.
So there will be a direction for production.
Yes, yes.
The maps before the.
Yes, yes. My lord, I will request, my lord, the Lord Advocate General's office to do it.
Let the HIDCO also produce.
Yes, HIDCO
their-
is nothing, my
their-
lord. HIDCO doesn't. I have checked up personally. I will effectuate, my lord.
Because his allegation is against the HIDCO. That HIDCO is encroaching.
Which, my lord, can only be answered by the state government map,
On the map.
acquisition map.
On the
Let the
acquisition map.
state government.
Yes, yes. My lord, may I have leave if your lordship?
Who, he is not even a party to this.
Party, madam.
In a contempt
so.
application, they are not the party. In contempt application, they are not. That's why I'm indicating the reference correspondence by the BLRO. In the contempt application, they are.
The special land acquisition officer, comma, here it is New Town, New
Yes,
Kolkata.
but my lord, we have sought from the land acquisition, special land acquisition officer, not 24%. My lord,
Should he have the map? Not 24 Parganas should have it.
it has been, my lord, forwarded by the bureau of the, my lord, it's my instruction.
Special land acquisition officer, comma, not 24 Parganas, is directed to produce the acquisition map before this court on first March.
First month.
ওটা on the adjourned date করুন। let the matter appear under the same heading on 1st March 2024.
Now the order should be communicated by the state, otherwise.
He is present in court, so I'm not giving a direction for communication. Please find out a solution to this, Mr. Protocol.
My lord, the thing, my lord, out of the court, my lord, I think, my lord, this particular plot in question is a vast area, and the particular plot in question is disturbed. A lot of cases I moved before lordships, not this particular case. I personally moved at least 5 or 6 applications. Particular plot in
But
question.
there was no difficulty in demarcation and
The
all.
difficulty is arise. Similar order has been passed by lords, my lords. Similar order, they are facing without a map. They have encroaching the property hit co, disturbance created, come before this court for demarcation.
Please come back, let me see. Please come back with the map. Next.
My lord, in this matter, my lord, I am for the petitioner. My lord, your lordships kindly see the order dated 9th of January 2024 of your lordships, my lord. On that day, my lord, your lordships directed the alleged contemner to file complaints.
Yes, my lord, entire thing has been passed, my lord. The zonal office has passed, the payments procedure has been cleared. My lord, another 2 weeks time, my lord, the direct payment should be made by the Bombay. I have specific instruction, my lord. And there is no dispute that we are liable to pay and we will pay the same. A specific instruction within 2 weeks, my lord, the payment will be released, my lord. Since there are some technical issues there, the normal payment is not that. It's not that. We have to pay the government department. That's why it is taking some time, my lord. I have specific instruction. Within 2 weeks, they will pay the same. Make payment of the same. Just 2 weeks accommodation, my lord.
Let the matter be kept.
Yes, my lord. I will file the compliance report within 2 weeks.
This is the
Letter of
last.
counsel for the alleged contemners seeks further accommodation for 2 weeks to comply with the order under contempt. Paragraph, let the matter appear under the same heading on 23rd February.
No, last chance. my lord.
23rd February,
No, this is the last chance. my lord.
affidavit of compliance we submitted on the urgent date. Please come back. They are ready to pay.
Yes, my lord. We will not, my lord. Everything has been cleared, my lord. There are some technical problems, my lord. Your lordship.
Sent for payment.
Yes, my lord. I am personally, I have been informed by the head office, my lord,
Yes.
that they will comply with the same.
Next.
Matter of 23rd.
My lord, 23rd, my lord.
February. Yes, who is appearing?
My lord, Mr. Tarok Karan is appearing on behalf of the state. He has not come to court.
What about the applicants?
Applicants ke ache?
I am for petitioner.
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 She is for the petitioner.
Yes, what is the matter about?
We need some time because we file already can application, but after last date, we received the opposition from the state. So we need some more time to reply our.
What is the application about? When elected by urgent, the state is known.
Last applications.
A learned counsel for the
তোমরা বলবে তোমাদের
applicants
application.
seeks to use an affidavit in reply in this matter. You want to come back with an affidavit in reply, is it?
Yeah.
Let the matter appear under the same heading on 15th March.
15th March, not for
15th March.
ওদের reply দেবো।
Next. Edit করে গেছিল। Next. Item 6.
Item 6, my lord, for restoration, your lordship, substitution, petitioner died. Or has,
Served the respondents.
yes, my lord, I served the respondent state. Service of them, sir. I've served it. Lord. Gulshanara Bibi Begum was the petitioner. She died. I have given her death certificate. Her husband and her son is proposing to be party in this case.
Have you served this to the respondents? Where is your affidavit of
Respondent,
service?
Lord, he said there to the state I have served. Lord. I've got the certificate of.
Are these
I-
Mr. Raja Shaha, Mr. Pritam Chaudhary, are they still in the state bank?
No, Pritam Chaudhary, I have Mohammed Pritam Chaudhary.
State bank.
He was the surveyor. He was appointed by your lordship for surveying the thing. That the local people is trying to demolish one house, saying that I'm encroaching the government land. But the surveyor was appointed. I don't know whether he has given report or not. But so far I know, I have not encroached anything.
No, which state advocate have you served?
But
State advocate?
state government, PP, GP.
Where is your affidavit of service? Where is your affidavit of service?
Service good. Dixie bhai, that I mean service notice है. Not your lordship see the service.
You should use an affidavit, sir.
That's I have got the receipt. That's yeah. But your lordship fix a date. Pritam Chaudhary, I shall also inform. I am in danger because they are local people who try to demolish my house on the plea that I have. Your lordship will find your lordship has the pleas to appoint the surveyor. Surveyor has given the has surveyed it, but I don't know whether surveyor has submitted report or not before your lordship. Pritam Chaudhary was appointed surveyor by your lordship by order dated 7/7/2020.
Your application is beyond time. Substitution petition. She expired in 2021. 6th April 2021.
Yes.
You filed your application on 6th November 2023. So it has abated already.
But I have
2 years.
I have got the information. Lord. That's why I have just. Yes.
You are for the petitioner.
Yes.
So you have the information immediately. They have the legal heirs.
Perhaps
I'm sorry, sir. Cannot be allowed. I have to reject this and dismiss the suit. It is abated already.
But then I suppose limitation for condonation of limitation not accepted.
Oh, you have to file an application for setting aside abatement.
It's not give a date more for this. See whether
On prayer of the applicant, the matter is adjourned. None appears for the state respondents. Paragraph, let the matter appear under the same heading on 18th March. Didi, eta fero din.
I think Civil Lordship, Mr. Pan is appearing on behalf of the petitioner. Due to his personal ground, Lordship, he could not come to the court, Lordship. Kindly make it not this week, Lordship.
You are the applicant in the review application.
Review application.
And the petitioner also.
Yes, Lordship.
The applicant petition on prayer of the applicant petitioner, Mr. GHOSH is
I'm for the respondent, sir.
on prayer of the applicant petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th March. 13th March.
Item 8.
To my lord, sir, this is the report, my lord.
Who is appearing?
Sir, I'm appearing on the behalf of the petitioner.
Yes.
The report has been served on 1st of February.
What was served?
The report was served on 1st February, my lord.
Yes.
We need 10 days
time. Sufficient time we've got already. Today is
Yes,
eighth.
but the advocate on record, his father is hospitalized, my lord.
Report in the form of affidavit submitted on behalf of the third respondent is taken on record. Paragraph on prayer of the petitioner, liberty is granted, petitioners, liberty is granted to use an exception paragraph where the matter appear under the same heading on March
14th.
Next.
Item 9, my lord, I picked up here for the petitioners. My lord. Now, this matter has come up after a long time, my lord. But on the last occasion, that is on 2nd of September 2009, but I believe, my lord, the panel may have changed, my lord.
My lord,
Should I serve a fresh notice upon the respondent and come back, my lord?
my lord, I am for the one of the private respondents, my lord, Bengal Aerotropolis Projects Limited. My lord, I am only praying for a direction to serve the writ petition upon me so that I can seek instructions on that.
Were on record earlier.
Yes, my lord. Three
My lord,
occasions.
we have not appeared before.
My lord, may I submit one thing? My lord, probably, my lord, the panel has changed for the respondents. My lord, should I come back after serving them a fresh notice? That would be better, my lord. Because, my lord, Mr. Debraj Basu had appeared for the Aerotropolis earlier also. Mr. Moina Ghosh and others.
You're appearing for the ninth respondent.
I am appearing for Bengal Aerotropolis. Now,
nine.
since I don't have the copy of the petition, I don't know the respondent number, my lord.
Yes, it's
Nine.
the ninth respondent
It's 9.
who was represented all throughout. So why do you need a copy?
We have recently been briefed in the matter. We have been told that we have to appear for the respondent number 9. Now, we don't have a copy of the writ petitions.
Represented all throughout. So I don't think there's a necessity for further service. Informally, if you can serve, please help me. I cannot give a direction.
Well, I shall.
And Mr. Johorlal and Mr. Shamimul Bari, they are no longer in the panel.
But probably, my lord, the panel has changed.
Panel. No, they are in the panel.
But in this matter, maybe somebody else has been, because, my lord, two other matters are going on before Justice Chatterjee, in court number 25. But there are different sets of advocates in that. Same allegations, same set of areas, same set of facts are there.
But here they were already.
Yes, madam. They were. But I shall serve a notice.
Please serve a notice
Yes,
indicating the urgent date.
Yes, madam. Yes.
No need of fresh service at the GP.
My lord. Grateful, madam.
They are still in the panel.
My lord, madam. I shall.
None appears for the state respondents. Paragraph, let the matter appear under the same heading on 14th March.
My lord.
Grateful, my lord.
Directed to serve notice upon the state respondents intimating the urgent date.
Well, under the same heading, my lord.
Yes.
Grateful, my lord.
Grateful, my lord.
On the prayer of the state respondents, my lord, your lordship allowed for demarcation of the lands which has been used without a
state respondents.
my lord, Mr. Bandyopadhyay, sir. They have filed the report. They admitted that the lands of the petitioners have been utilized. Plot number 18 and 9. And so there is questions of the my lord without acquisition. So the questions of the payment of the my lord, the compensation also the recovery. On the other date, also time was sought for by the state respondents for the file the report. May I kindly see the past report. The report filed on that date on 16th November 2023. The report 16th December 2023, a copy was handed over. They admitted that the LR plot number, your lordship's got it, my lord.
When was the report filed?
My lord,
December 2020.
my lord, two reports are filed. My lord, one report was filed by on behalf of the respondent by the executive engineer. It also appeared
Oh, this is not in the form of an affidavit. This is just a
No,
paper report.
not in the
Not in a
form
form of affidavit.
Yes, what does the report say?
Well, kindly see the report says that kindly see that report that as per field demarcation, the demarcation report of the revenue inspector, hand sketch map prepared Amin and assistant sir. First, the LR plot number 907 of Mauja such and such is not involved with the pipeline of the PHA department. There is an existence of the pipeline. Two, very important, kindly see the point 2, that LR plot number 908 and 909 of Mauja such and such are involved with the pipeline of the PHE department. On the plot number 908 and 909 of the said Mauja, there is the existence of the PHL pipeline which located under the staging area of the railway line as per available RS Mauja. Here the RS Mauja, they have stated kindly the RS Mauja and also the Bengali report by the kindly see.
Your claim is in respect of plot numbers?
907, 908 and 909. However, 90, my lord, they stated
6, 7, 8, 9, 10.
yes, but now they have admitted my kindly see clause 4, the Bengali my lord, report, my lord, take my third page. 906 দাগের কিয়দংশের মধ্য দিয়া উক্ত পাইপলাইন গেলেও উক্ত অংশটি আবেদন এটি my lord, clause 4, 909 দাগটির সম্পূর্ণ অংশ Bengali kindly see 4 and 5, they admitted.
So 908 and 9, these
Nine.
two thugs, they have admitted.
Then kindly come the case map which they have annexed entire.
What about 910?
My lord, kindly see 909 and 908, the pipeline, my lord, the executive engineer also admitted that the major portions of those lands have been utilized, causing damages to the lands. It will appear from the report itself, my lord.
Yes, so 908 and 909 you are entitled for these two.
I am entitled, my lord. I am disputing that it is the long, kindly pass the order.
Yes.
My lord, in this regard, whatever submission is required on the part of the state government, there is a specific instruction on the part of the who is lying, Mr. Bandyopadhyay. My lord, kindly on the next course of action, kindly make it date so that a state can submit.
My lines have been laid under.
My lord, we have admitted.
Why do you require further time? Not necessary. Assess the compensation and pay to the petitioner for these two thugs.
My lord, kindly record the assessment of the what amount of compensation he is required to further. This record.
That the court will not decide, that the authority has to decide.
My lord, I know, my lord, kindly make it one date so that we can apprise before your lordship.
On the earlier date also, you were not represented. So on the next date, whether the respondents are there or not, an order will be passed.
My lord,
Please keep that in mind.
my lord, I will inform you.
Because I am not happy with your representation. You appear one day and then next 2 days you are not there.
My lord.
If you are not interested, please leave the brief.
My lord, I will communicate to the my senior.
On prayer of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 28th February. Because nothing further remains. I'll dispose it off. Next.
20th February. Yes.
Ms. Roy has not much of a role to play in this
No,
matter.
my lord, I have no role, Lordship. Lordship, in this matter, Lordship, I carried as an added party. I have no role, my lord.
But actually, in the process of widening the NH, their land, they shifted the pipeline mile there. Also, they are also sometimes they are my lord.
Item 11.
Lord, item 11, 12, 13, and 14, these are four matters. My lord, may recall that matters. My lord, in this matter, we took the point of maintainability,
Suppression of material facts.
suppression
That
of
was your
material fact.
point.
My lord, on that score, my lord, on the last occasion, my lord, I handed over copies of 3 orders. If your lordship kindly takes up the order dated 17 December 2004, passed in the appeal,
Yes.
that is initially that was numbered as AST.
Yes.
Because I have taken that point, that challenging the same acquisition proceeding. Some owners, that is the forum, one association, of which the petitioner's hearing was also the member, moved a rate petition. My lord, initially, an interim order was granted. Against that, we, the KMDA, preferred an appeal. In the appeal, this order was passed. Lordship, kindly have a look. The order, may I read the order? Because this orders request to be read. 17, I am reading, my lord, 17 December 2004 order. After having heard the learned counsel for the respective parties, it appears that the delay has been sufficiently explained. Inasmuch as after the order was passed, steps were being taken to get the order vacated, but for some reason or other, the matter could not be taken up, and as such the delay. The urgency that has been pleaded that a very important subject for which the funds has already been given, casting liabilities in default, are to be utilized forthwith. The ensuing vacation is posing an apprehension to the appellant that the matter might be further delayed. Therefore, the present appeal has been preferred along with an application for leave to appeal and an application for condonation of delay. After having heard the learned counsel for the parties, we allow both these applications being AST number so and so, when we grant leave to prefer this appeal and condone the delay. Let the appeal be registered. In view of the urgency pleaded by Mr. Bhattacharya and Mr. Rai, learned Advocate General, by consent of the parties, the application for stay being AST number so and so is treated as on day's list for hearing. Respective counsel for the parties had addressed the court on the question of stay on merit. We propose to dispose of the application for stay in the following manner. In this case, pursuant to a project planned in 1976, land was sought to be requisitioned in 1984 under the West Bengal Land Requisition and Acquisition Act 1948. A writ petition was moved challenging the said requisition, being CO number 16526 of 1984, since disposed of on 17th September 1984 by Honorable Ojish Kumar Sengupta J, as his lordship then was. In the said order, the following directions were given. The respondents shall take symbolic possession of the vacant lands, excepting in those cases where notices have been served against the dead persons. The respondents shall issue fresh notices upon the proper persons and thereafter shall take symbolic possession of such land. At the time of taking symbolic possession, the respondents shall make a survey how the lands which are being taken possession of are being used by the owners. The respondents shall not take any step for acquiring the lands until the present cultivation season is over and the harvesting is complete. Number 3, in the meantime, the respondents shall address the market value, assess the market value of the lands provisionally, and shall pay 75% of the compensation on the basis of the market value to the owners of the lands to enable them to have a new source of livelihood where such persons are entirely dependent on the said lands. The respondents shall take actual possession of the lands after payment of 75% of the compensation as directed by this order, and only after the end of harvesting season, in any event not before 15th January 1985. It is contended on behalf of the state by Mr. Rai that the 75% of the compensation in terms of the said order was deposited in 1986. However, Mr. Mondal, for the writ petitioner's respondents, contends that no notice of such deposit was ever given to his clients, and his clients are not aware of the same. A notice under Section 41A of the 1948 Act was given in 1986. Pursuant to the said notice, it is contended that since it is a notice under Section 1948 Act, the date of notification shall be the date of vesting of the property in the state. It is also contended that on account of requisition, the possession, whether physical or symbolic, would be with the state, though physically it may not be in the possession of the original owners. Mr. Mondal, however, contends that the possession was never taken and his clients are in possession of the property. Mr. Mondal submitted that in an affidavit, the appellant's KMDA had contended that 80% payment had been made in 1990. Be that as it may, it is neither here nor there. Now question is whether order of status quo, since appealed against, is to be stayed or not. There is no doubt about the urgency and the purpose of the acquisition. Though it is contended that the 1948 Act has since lapsed, yet that would not matter since the proceeding for determining the compensation was over before the 1948 Act ceased to exist. However, on the cessation of 1948 Act by reason of amendment incorporated in Section 9 of the Land Acquisition Act applicable to West Bengal, the proceeding for compensation can still be pursued and carried on under the Land Acquisition Act with regard to the reference, etc. Out of such award, provided the limitation has not set in. All these questions shall be determined at the time of hearing of the appeal. It may be noted in the decision dated 17 September 1984 in CO number 16526 of 1984, the requisition was neither quashed nor held to be irregular or illegal. Admittedly, no appeal has since been preferred against the said order. Thus, the said order has reached its finality. Therefore, it appears that the validity of the requisition is no more open to challenge after the said decision. The directions contained in the said decision clearly indicate the entitlement of the claimants to claim compensation. The directions were aimed at protecting the interest of the claimants in receiving the compensation. The said directions contained mode, method, and manner of taking possession upon payment of 75% compensation. The rights of the writ petitioners therein, who have preferred the present writ petition, are confined only to the receipt of compensation and nothing else. That apart, the said decision would operate as constructive res judicator, even if the present questions involved in the present writ petition were not raised in the earlier writ petition, but could have been raised, were deemed to have been raised and decided against the petition. Thus, it is crystal clear prima facie that there is very little scope available to the writ petitioner in the present writ petition to obtain any relief other than those which were provided for them in the earlier writ petition. Prima facie, we are of the view that there is practically no scope or prospect of the petitioners being successful on the questions raised in the present writ petition, not only on merit, but also on the ground of delay. Apart therefrom, Mr. Mondal had contended that the original claimants had in the meantime transferred their interest in favor of the present petitioners, who have stepped into the shoes of the original claimants. According to him, the valuation of the land has increased phenomenally, and that no possession having been taken and the validity of the requisition having been challenged and the 1948 Act having lapsed, the proceeding cannot continue. The submission of Mr. Mondal is devoid of any substance. If the petitioners are the transferees subsequent to the requisition in the absence of the original owner at whose land the lands were requisitioned, transferees cannot raise any question with regard to the validity of the requisition or the acquisition, as the case may be. Post requisition, an acquisition transferee acquires no interest in the property requisition or acquisition. The transferee acquires only a right to the compensation and nothing else. If the award is already made, they would be entitled to the award, and if it is still open to seek reference, they would be entitled to seek reference for enhancement of the amount of compensation. Their right is limited only to the extent and no further. Thus, we find that there is very little scope to sustain the writ petition and to continue the interim order of status quo, having regard to the facts and circumstances as discussed hereinafter, as well as the discussion made hereafter. However, it appears that the purpose for which the development of a satellite town, which is one of the essential services contemplated under the 1948 Act, and therefore validity of the purpose prima facie does not seem that the same can be assailed. The only benefit the petitioners can get in an added compensation or enhanced compensation. In case the requisition or acquisition is set aside, in the event the state is free to issue a fresh notice to acquire the same, which will enable them only to claim enhanced amount. Supreme Court, in the decision of Ramnikhal N. Bhutta versus the state of Maharashtra, reported in 1997 1 SCC 134, had held that having regard to the development of the project, it was held that the court should not be oblivion of the situation, and in such case grant enhanced compensation instead of granting stay or by shifting forward the date of notification, as was held in Ujjain Vikas Pradhikaran versus Rajkumar Johri, reported in 1992 1 SCC 328. It was also observed that despite such view taken by the apex court successively, the said principle did not percolate to the high courts, due to which those observations in Ramnikhal and Bhutta Supra was recorded. We had occasion to follow the principles laid down in those decisions in Ritkaran so-and-so, reported in 2004 4 CHN 327, and in Kolkata Metropolitan Development Authority versus Mahendranath Memorial Society in MAT number so-and-so, which was disposed of on 24th November 2004. In the circumstances, without prejudice to the rights and contentions of the writ petitioners respondents, we direct that the operation of the order of status quo passed in the writ petition since appealed against shall remain stayed. This order will continue for a period of 60 days after Christmas vacation, within which the amount deposited as compensation shall be released in favor of the persons after identifying their entitlement, provided the individual claimants apply for release of this amount before the collector Howrah, who will dispose of each such application within a fortnight and latest within 4 weeks from the date of making of such application. However, the period till making such application in each individual case shall be excluded for the purpose of continuing the 60 days during which the stay shall remain operative. The receipt of this compensation by the respective claimants shall be without prejudice to their rights and contention in the writ petition and the appeal, and to seek reference if they are entitled in law, and also to claim enhancement of the valuation if any reference is made. This order is also subject to further order that might be passed in this appeal itself. We, however, keep it open to enhance compensation already awarded in terms of the apex court's decision so and so at the time of hearing of the, if the circumstances so warrant. We keep all points open in case any application is made and the amount has not been released on account of any dispute with regard to the claim. In that event, the same would be referred to the learned district judge under section 30 of the Land Acquisition Act for apportionment or appropriate decision. In case any amount despite being payable to the claimant is not paid, in that event the collector shall prepare such check and bring the same to this court on the date when the appeal is fixed for hearing. While releasing the amount, the solatium, additional compensation and interest as payable in terms of section 7 of the 1948 Act, read with section 23 of the Land Acquisition Act, be included and paid. It will be open to Mr. Mondal's client to receive the principal amount immediately on the application, and the collector shall determine the compensation of solatium, additional compensation and interest within a fortnight thereafter, and pay the same within 6 weeks of the making of such application. In case any additional fund therefore is needed, the collector shall forthwith inform the KMD, which will furnish such fund forthwith. The collector shall
payment part.
Yes. My lord, thereafter, Lordship kindly take up the subsequent order, that is 8th February 2005.
Yes.
My lord got it like this.
Yes, yes.
This into this. 8th February. Appeal. Yes. Bunch করেছি। May I read? This is 8th February 2005. On 17 December 2004, this refers to the earlier order, which I read. On 17 December 2004, we had passed an order pursuant to which payments were to be made to the claimants. Mr. Banerjee, appearing with Mr. Bolai Roy, learned Advocate General, submits that payment have since been made. 7 of the 8 petitioners have received the checks. Mr. Mondal, learned advocate for the respondents' claimants, submits that these 7 persons are not the 8 petitioners, but admittedly they are claimants. 21 checks have been shown to us, which have been made ready for payment, but no one has come to accept the same. A list of claimants has also been produced. A copy of such list is handed over to Mr. Mondal. The claimants may approach before the land acquisition collector and receive the checks without prejudice to their rights and contentions, provided the checks are issued in their name. In case of any dispute with regard to the claimant, in that event, he may apply to the land acquisition collector, giving particulars of the rights under which the claimant is making the claim. The land acquisition collector shall exercise his power under section 30 of the Land Acquisition Act and determine the person to whom such compensation is payable. And after such determination, he shall pay the amount of the compensation to such person. The exercise must be completed within a period of 1 month from the date of making of such application. In case it is not possible by the land acquisition collector to make the payment, in that event, he will communicate in writing to the person indicating the reason for his inability to make the payment. In such case, the land acquisition collector shall make a reference to the court under section 30 of the Land Acquisition Act within a week from the date of his decision. The court to which the reference is made shall determine the case after giving notice to all the concerned parties in accordance with law as early as possible, preferably within a period of 6 months from the date of such reference. Mr. Mondal, however, contends there are certain other claimants who are recorded owners, but no payment has been made. Xerox copies of such applications are being produced before this court. Let the Xerox copies be handed over to Mr. Banerjee, who will pass on the same to the officers of the land acquisition collector. After receipt of the said copies of the land acquisition collector shall scrutinize the applications and find out whether they are recorded and they are entitled to get compensation. In that event, the land acquisition collector shall make payment of compensation within a period of fortnight from the date of making of such application. In case it is necessary, he may exercise his jurisdiction under Section 30 of the Land Acquisition Act, and he may decide the same or refer the case to the court if occasion so arises on the same direction. As has been given earlier in the order, shall be repeated in respect of other claimants. There are other claimants who claim to have purchased the interest of the original owners. These claimants shall make appropriate application before the land acquisition collector, together with the particular of their claim and the copies of the relevant documents, the original whereof are produced in course of hearing. Upon such application being made, the land acquisition collector shall give notice to the respective parties and determine the question within a period of 4 weeks from the date of receipt of such application in accordance with law in the same manner as was directed earlier hereinto. The project, however, shall continue and shall not be forestalled for any reason whatsoever. In case of any dispute with regard to the claim, the same may be subject to the further order of this court or a reference under Section 18 if it is so preferred. The claimant shall be at liberty to apply under Section 18 if they are so advised and if such application is not barred by law. However, we repeat that the payments and the receipts of the compensation by the respective parties are without prejudice to the rights and contention of the parties in the appeal, subject to further orders that may be passed by the Honorable Court, by this court. Let this matter be listed for hearing so and so. My Lord, thereafter, the appeal was disposed of.
The same acquisition case.
Same acquisition case. My Lord has seen that after this order, nothing remains in the acquisition except the payment of compensation. Then, my Lord, the writ petition was finally heard and disposed of. Lordship kindly takes up the order dated 27 July 2010. After the appeal was, my Lord may take note of the date, my Lord, I could not collect the order. The appeal was finally disposed of on 11th May 2007. This appeal was finally disposed of on 11th May 2007. Unfortunately, my Lord, I could not collect that order at that time. The server was not available. Then, my Lord, the writ petition was finally decided. Lordship kindly takes up the order dated 27 July 2010.
Yes.
Mr. Mondol appeared for the petition. আমি খুব ভুল করতেই পারি না হ্যাঁ 2010 My Lord got it?
Yes.
My Lord, may I go? In this writ application, the petitioners have challenged the entire acquisition proceeding, being LA case number 25, Act 2, CMDA of 1984-85. Here, the same LA case, as illegal and invalid on the ground that there was no notice of acquisition of land as provided in subsection 1A of Section 4 of the Act 2 of 1948. A notice of acquisition under Section 4(1)A of Act 2 of 1948 was published in the Calcutta Gazette on 7th April 1987. The entire basis of the challenge in the writ petition was want of notice under Section 4(1)A of the Act 2 of 1948. The grounds thus fails. The Mr. Mondal, appearing on behalf of the petitioners, referred to an order dated 17 September 1984, passed by the passed by His Lordship, the Honorable Justice Ajit Kumar Sengupta, as His Lordship then was, in Civil Rule number 16526. My Lord has seen the appeal court also took note of the order.
It was 7th of December, not September.
It was 17 September. 17 September. My Lord, that was quoted.
Oh, 1984, yes.
Yes. 1984. Here, my Lord, I am not troubling your Lordship. Here, this portion I have already read. This was quoted in the appeals court order also. My Lord, I am skipping that. The order dated 17 September 1984 restrained the respondents from taking actual physical possession of the land in question till the cultivation season was over and harvesting was come. The respondents were in the meanwhile directed to assess the market value of the land provisionally and to pay 75% of the compensation on the basis of the market value to the owners of the land to enable them to have an individual source of livelihood where such persons were entirely dependent on such said land. The respondents were directed to take actual physical possession of the land after payment of 75% of the compensation as directed by the order dated by the order, and in any case not before 15 January 1985. The original writ petition has been amended. Even when the amended writ petition was filed, the petitioners were still in possession. There was a restraint order restraining the respondents from taking possession before the end of harvesting season, that is before 15 January 1985, and possession was not taken before 15 January 1985. The records pertaining to the case were produced. Award of compensation has been declared and in most cases disbursed after giving the owners opportunity of hearing. Mr. Mondal, appearing on behalf of the petitioner, did not dispute the fact that notice under section 41A of Act 2 of 1948 Act had been issued. Mr. Mondal also did not dispute the fact that award of compensation has been declared. Mr. Mondal submitted that respondents had acted in violation of the order dated 17 September 1984 in that 75% of the compensation had not been paid in advance. On a reading of the order dated 17 September 1984, it is clear that His Lordship did not restrain the respondents from further proceeding with the acquisition before payment of compensation. The respondents were directed to pay 75% of the assessed market value before taking actual possession. There is not a whisper, even in the amended writ petition, to the effect that physical possession had been taken without award of compensation. Mr. Mondal very rightly argued that any action in contravention of an order of court is a nullity. However, this court is unable to hold that the acquisition in this case is in violation of any order of this court. The writ petition thus fails and the same is dismissed. So validity of the acquisition proceeding was decided and it reached finality. There was no appeal against the division bench order, as also the order passed on 27 July. Now, my Lord, on the last occasion, Lordship wanted to see the prayers made in that writ petition. That is, since the records are not called for, my Lord, I have made copies of the two documents which I have. Lord, if you Lordship kindly have a look. This is, my Lord, there was some marking. Lordship, kindly excuse me.
May I take a copy of this document? But no copy has been given.
You have appeared before the court.
No, I appear thousands of cases. That does not mean I have all the records with me at present. This is a separate case.
No,
nowhere in the previous petition, present petitioners were parties. So I am not supposed to bring any record for them.
On the last occasion, my Lord, Lordship wanted to see the prayer. And I also prayed that let the records of these cases be tagged. Lordship told me
is different, but the acquisition case is same.
acquisition case is same. And Lordship was of the view that since I am having a copy of the writ petition with me, my Lord can see from. But for the convenience of the court, my Lord, I have made another copy. If my learned friend wants, my Lord, I will make a copy and give it. No issue. Lordship will, in the cost title, earlier it was the practice of this court, my Lord. We used to, my Lord, incorporate in the cost title the subject matter of challenge. If your Lordship kindly comes to page 2 of the writ petition, Lordship will find that precisely we used to mention the word, what is under challenge. If your Lordship sees that the Land Acquisition Act, number 2, and in the matter of purported attempt to requisition the land at Bankra, jail number so and so, of the members of the petition number 1, that is the forum, Nagarik forum. Then pro forma notice the LA case number 25, CMDA, Act 2 CMDA of 1984-85, under section so and so. Then Bakra Nagarik committee, the petitioner, then along with 7 others, versus the state. Now, Lordship, kindly have a look the prayers at page 31. It starts from page 30.
Yes.
A is regarding grant of leave. The B, a writ in the nature of mandamus commanding the respondents to act according to law and to forthwith recall resin, revoke the purported land acquisition proceeding arising out of LA case number 25 and 28 CMDA of 1984-85 in connection with the purported West Howrah Township project. Then also see also the same thing 25 of 1984-85.
And the prayer herein also is the same.
Same. So the LA proceeding, the LA case 25 was under challenge in that writ petition. This was moved by an association. And in the writ petition also, some of the petitioners were the members of that association. With that, even if the petitioners were not the members of the association, but the same acquisition proceeding was challenged before the court, and that was decided by the Honorable Single Bench as also by the Honorable Division Bench, and that order was never challenged. That reached finality. And on merit also, my Lord, nothing remains after these 2 orders, my Lord. Nothing remains to challenge the acquisition proceeding, being the LA case number 25 of 1984-85 on any ground whatsoever. But that apart, the point which we have taken, my Lord, regarding the maintainability of this, that despite these 2 orders, Mr. Mondal is for the petitioner in the instant writ petition also, and in this proceeding also before the division bench, as also before the single bench, Mr. Mondal had the occasion to appear. But in the writ petition, nothing, not a single whisper has been made regarding this proceeding. So this is a gross suppression. Mr. Mondal cannot avoid this. Though no petitioner was someone else. Here the petitioners are other. The advocate was the same. But this has advocate on record as also the counsel
Even if
Both
the
were the
petitions
same.
are different, the same acquisition case, it has been
Same.
decided already.
Same.
It's res judicata also.
The judicata is barred by res judicata also.
Let us hear Mr. Mohan.
So on the ground of suppression, my lord, this is according to my humble submission, my lord, this is suppression. Purportedly, huh? No, that aspect has also been, my lord, on merit. We have, my lord, grounds we have taken in our affidavit. My lord, he is also the post-vesting transferee, and that aspect the Honorable Division Bench has taken care of. That has
Let us see if we can reach till merits at all.
yes. My lord, on this, my lord, on the point of suppression, my lord, since I have taken that magnanimity point, other points after Mr. Mondal argues that I can open only. My lord, I shall rely on only two decisions of the Honorable Supreme Court, my lord, on the ground of suppression.
This is settled law. Settled law. One must come with clean hands.
Yes, yes. And even then, my lord, for my satisfaction, let it do the activity. My lord, this is 2004-7 SCC 166. 166.
Yes.
My lord, paragraph 13 to 17. My lord, may I read? As a general rule, suppression of a material fact by a litigant disqualifies such litigant from obtaining any relief. This rule has been evolved out of the need of the courts to deter a litigant from abusing the process of court by deceiving it. But the suppressed fact must be a material one, in one sense that had it not been suppressed, it would have had an effect on the merits of the case. It must be a matter which was material for the consideration of the court, whatever view the court may have taken. Thus, when the liability of income tax was questioned by an applicant on the ground of her non-residence, the fact that she had purchased and was maintaining a house in the country was held to be a material fact, the suppression of which is entitled her to the relief claim. Again, when in earlier proceeding before the court, the appellant had undertaken that it would not carry on the manufacture of liquor at its distillery, and the proceedings before this court were concluded on that basis, a subsequent writ petition for renewal of the license to manufacture liquor at the same distillery before the High Court was held to be initiated for oblique and ulterior purposes, and the interim order passed by the High Court in such subsequent application was set aside by this court. Similarly, a challenge to an order fixing the price was rejected because the petitioner had suppressed the fact that an agreement had been entered into between the petitioners and the government relating to fixation of price, and the impugned order had been replaced by another court. The next also based on facts. Assuming that the explanation given by the appellant that the suit had been filed by
This issue has been discussed.
yes. The next one is 2010, Volume 2, SCC 114. Hey, Dada. Paragraph 4 and 7.
দেখা যাচ্ছে। Paragraph
4 and 7. Paragraph 4 refers to another decision where it has been held that a party which has misled the court in passing an order in its favor is not entitled to be heard on merits. Then Lordship kindly come to paragraph 7. This refers to another judgment that where it was held that in exercising the power under Article 226 of the Constitution of India, the High Court is not just a court of law, but is also a court of equity, and a person who invokes the High Court's jurisdiction under Article 226 of the Constitution is duty bound to place all the facts before the court without any reservation. If there is suppression of material fact or twisted facts have been placed before the High Court, then it will be fully justified in refusing to entertain a petition filed under Article 226 of the Constitution. This court refers to so and so. Milord, in the earlier judgment, the 13, the first two lines, Milord, had it been a fact, Milord, since I am aware of this, Milord, I could bring it to the notice of the Honorable Court. But this has been suppressed purposely in order to obtain a favorable order. So on the ground of suppression alone, apart from other infirmities, Milord, there are several grounds we have taken. Right from the post-vesting transferee, there are other grounds, Milord, we will argue later on. So this is my own preliminary objection.
Yes, Mr. Monroe.
The only point taken by my learned friend that there is a suppression of material fact. This cannot be a point of preliminary point because suppression of facts has to be proved from the facts of the case. So let me place the facts of the case. Thereafter, your lordship consider whether I have suppressed the fact or not. Before that, it cannot be considered whether there is a suppression of fact because the present writ petitioner were not the writ petitioner in the previous or subsequent writ petition.
The same LA proceeding was challenged in the earlier writ petitions?
I, as a lawyer, challenge, but not the present petitioner.
You did not represent anyone, you were in your personal capacity.
Yes, I am a lawyer. I can, if I appear for state in one case, that does not mean I have to remember that case in the other state matters. As a lawyer, I have not, because a person is responsible for suppression of material fact, not on lawyer's ground. Lawyer may be the same. I am not supposed to keep in mind all the cases.
Will you continue some other day? Let me take up the other matters. It is taking a very long time.
No, only one point. There is still half an hour.
Let me take up other matters also, sir.
No, I have no objection.
As your lordship.
Because you have completed your submission. I'll
Yes,
get a
yes.
submission on the next
Mr. Mondal will reply on this point, and later on, Milord, we will argue on other points.
So only one point here is taken. No.
Suppression.
Suppression. Yes.
Suppression. Yes, I will answer to that.
Third learned counsel for the KMDA on the issue of maintainability. Paragraph. Let the matter appear under the same heading on 28th February.
Can it be on the first week of March?
7th March.
Practically, Milord, this is a hearing matter. Can it come at 3:30?
No, I'll just hear Mr. Mondal on the next day. Let us deal with this.
This issue first. Then, my lord,
Then your lordship will
Then if you
consider
feel
whether.
evidence are required, we'll go in. Let us.
that we have exchanged. Affidavits are reports.
are
Yes,
exchanged.
reports exception.
Report
Report exception. That is.
Because evidence will declare whether.
11, 12 and 13, same order.
Yes,
Yes.
same order, same order.
11, 12,
13,
13 and 14. Up to 14.
Okay, 8th March.
7th March.
It's 7th March.
7th.
Okay.
Yes.
Madam, for the petitioner, the respondents were supposed to reply on their report, my lord. You should kindly recollect, they are supposed to make the submission on their report, pointing out our point in the application.
Is it that matter where you are? the-
Right to fair compensation.
There's several matters, my lord, in group.
Right to fair compensation.
Yes.
পনেরো কি আপনি অ্যাপিয়ার করছেন?
No, in 27. My lord, I appear in serial number 27.
Who is appearing in 15? Yes. This is 15. Yes, please make your submissions.
My lord, every day they are taking adjournment.
My lord,
Last location.
may I place, my lord, this 27, serial number 27?
Together.
My lord, 27.
These are not together, my
No,
lord.
not together.
On the last occasion, my lord has specifically directed that
It
the
will
matter
be hard
taken up one
separately.
by one.
Yes, yes.
Yes. Then 27.
Appearing one by one. 24th to.
Although all the matters are
together.
coming together, but my lord has directed, no, I will take up only one matter one by one.
That should be proper.
Yes,
I
my
think.
lord. Otherwise,
Absolutely proper.
the matters will be jumbled up.
Let there be an adjournment. Please be ready on the next occasion, sir. I will not grant adjournments like this.
Well, I'm for item number 17.
This is 15. 15 is being adjourned.
Yes.
And when one is adjourned, I think the entire list gets.
My lord, other matters can be taken up. My lord, 27, I am ready, my lord, I will place.
Let
can
me
be-
call one by one.
My lord.
On prayer of the Metro Railways, the matter is adjourned. Paragraph with the matter appear under the same heading on
Ready আছে তো। তাহলে বলছে যে test করবো।
21st March.
Like, maybe call. Can it be on only not this week, my lord?
It will take some time actually. That's why I'm deferring.
My lord, as your lordship deems fit. 21st March.
Because one will cover all the other matters.
Yes, yes,
It's the
absolutely.
same issues.
Same issue, same land, everything is same. Only the petitioners are different.
Petitioners are different. Right. Same order. Please come prepared on the next occasion, sir.
Metro not submit the damage report.
Okay.
Already sent to.
I do not know all that. Please be ready. I'll dispose of the matter on the next occasion.
My lord, 17, I am for the Metro Railway.
Yes.
My lord, here my respectful submission will be, my lord, that
You submitted your report.
yes, I have submitted my report, and the documents that were needed or that was asked by your lordship, my lord, to be furnished to justify the grounds taken in the report. That was not there in the report. So, my lord, supplementary affidavit also I have filed.
Yes.
So, my lord, everything is ready. The only thing is that
What is ready? The compensation.
no compensation has already been paid. Then only possession has been taken over. So, my lord, the initially there was claim, and that was decided. The initial claim was raised by the appellate authority, and subsequently, my lord, that has been paid. And the appellate authority's order was passed on 31st of October 2018.
and possession has been taken over in 17/9/2019. So, my lord, before making payment, my lord, possession was not taken over. So, my lord, their only case is that possession was taken over from the date of notification, and possibly my learned friend has given some amount of glorification in the issue, but that is not the factual matrix of the case. The only question is that before taking possession, the entire amount has been paid and they have accepted it. Now they are claiming the interest, but after the pronouncement of the judgment in appeal, my lord, on 31st of October, the 1 year period that has been taken for possession, and there is no such delay or deliberate delay. That's why, my lord, the Section 80, initially Metro Railway Construction Act, they filed the claim. Then they revised it and they filed it in right to fair compensation. My lord, Section 80 clearly speaks, my lord, if there is more than 1 year delay or like that, then only the question of interest comes. So now here, my lord, the question is the much ahead of the specified time, my lord, the payment has been made and possession has been taken over after a lapse of 1 year from the date of judgment in the appeal court. So, my lord, I believe that this application is primarily misconceived. I leave it to your lordship, my lord. I have nothing to add more.
Yes.
We are only going.
Only one submission may I make? As the points are all the same, and only the land that is also same. Notification two, there are no two notifications. So, my lord, if this matter can be taken up only after item number 15, so that will surprise the entire. That is my otherwise picking up from.
I wanted to dispose of all the matters together.
Right.
Because
And my lord has directed that I will hear on the facts one by one and I will dispose of all the matters together. It was the direction. What has
there may be a conflict. In one matter, I decide in your favor. In the second, I decide against
yes,
you.
ma'am. That is why I am making
what
this.
comes with the consequence?
Absolutely, absolutely. That is why I am making this submission. Otherwise, I would not have made this submission.
You say that possession was taken before payment of compensation. Yes. And there is a reply to an RTI, I think, which says.
Yes, my lord has correctly corrected.
It says.
Yes, yes. And my lord, they were supposed to provide some document as to the payment and.
No, I have already by way of supplementary.
Received the compensation.
Yes,
you are asking for interest.
Yes, yes.
The 9% and the 15%.
Yes.
Section 18. Yes. Right.
See, interest part is very much specified.
In item number 15, Mr. Agarwal was appearing. Mr. Agarwal was appearing. Mr. Agarwal was appearing. He submitted that he needs to submit some additional documents by way of some supplementary affidavit.
That's why I've requested Learned Counsel to be ready on the next occasion. So file the report at least, or please give a copy to the petitioner so that he can go through it.
Well, in my matter, everything is complete because I have served them as well as it is with your lordship's brief.
In fact, the difficulty is one matter will guide all the other matters.
Yes,
isn't it?
because it is analogous.
Yes, not really analogous. Some of them are. Some of them are. 24 to 33, I think, are analogous. 23 to 33, 11 matters are analogous.
The date of compensation is different. Date of passing the order in appeal, that is also different.
The issue is
same point of view.
Lord, the section 80 has been claimed. Interest under section 80 has been claimed.
The amount of quantum of interest will differ in each of the
that
cases.
will differ, and the facts, my lord, regarding that when the order was passed
but in
by the competent authority, appellate authority.
The contention is that possession was taken before compensation.
Their contention. But Metro Railway's contention, my lord, there was the taking over, handing over, my lord, of the possession. And that
documents were duly signed by the parties.
But so far as I can recollect, you had said that we started our construction from one end. We did not take possession of the entire.
This is their contention, my lord. But there is no evidence to seven, except they are saying that there is the RT that
They have relied on RTI letter.
RTI.
They have relied on their reply that the position was taken.
Taken, right. You have stated a date of possession in that RTI reply.
My lord, my lord, their contention, the RTI that reply. But here, my lord, if that is so, my lord, here they are handing over and taking over possession, my lord, that document duly signed. And contention of the Metro Railway is this, my lord, after payment of compensation, possession has been taken. So therefore, the section 80 is not.
There is no document showing taking over of possession.
No, my lord.
The RTI reply.
No, my lord,
Your
that document is there.
I have filed.
That
That they
document
have
is
taken
there.
over position after payment of compensation. Yes.
RTI letter shows that the
In supplementary.
construction was started much before.
My lord, some photograph is annexed that will not reveal that is going on construction on that particular plot.
Really don't mean anything.
My lord has
Rely much on photographs.
considered only that RTS, and they were directed to give their reply as to the contention of that RTS.
Where is the document of possession in your reply, in your supplementary affidavit? I do not find.
My lord, the problem
The
is, my
certificate
lord,
of possession.
they have taken over position on 17/9/2019.
Where is that document?
Documents are
That is with the supplementary affidavit possibly.
Page?
Lord, that is the problem, Lord. The original file is not with me. The file that is available with me, my lord, that I have asked from them, because I have somehow.
If you come back on the same date, in that case,
same
let all the matters come up on the same
In
date.
27th, my lord, in my case, my lord, that is the annexed. In my, my lord, in my
The affidavit, the
in my report.
possession.
Regarding position, my lord.
Show me, I will just
My lord. This is the date of possession, my lord, and duly signed by the claimant and the Metro Railway.
আমার ক্ষেত্রেও দিয়েছিলাম।
A land which was purchased in 5 lakhs and compensation has been paid 2 crores 51 lakhs. Still,
that cannot be point of.
Still, but public money, my lord. This is after Metro Railway is the, my lord.
Public is also entitled for the
Absolutely.
I give with all of them together. That will be better. Right?
As well, lord.
My lord, the same order is also annexed. May I?
In your supplementary.
Yes, may I get a copy of this? My lord,
I
since
believe, my lord, today also Mr. Mr. Agarwal is not filing the supplementary IP.
the same
Yes,
document.
are you ready with your supplementary affidavit? That you have said already 10 times, sir. But are you ready with your supplementary affidavit? That's what I had asked.
আমার ফাইলটা আমি মিসপ্লেস করে ফেলেছি কোথায় আর বলো না অরিজিনাল ফাইলটা অবশ্য তোমাদের কাছ থেকে দেখে নিতে পারবো অ্যাপ্লাই করা আছে
No, only the prior service of that affidavit may be directed, my lord. Because otherwise they will hand it over in the court. Again,
He's insisting on a service today itself. Please serve a copy today itself. File it on the next date, right? Please serve a copy today.
You are in 20.
On heard learned counsels for the parties, let the matter appear under the same heading on ওই ডেটটা দিবে বললাম 21st March বললাম the same order is being passed in all the matters because
Well, I will place my, my lord, report separately, my lord. When the matter is called, I will place
I
my
don't think you yes you can but
27.
then your matter is tagged with several other matters.
my lord.
23 to 33 are together.
My lord,
You are in 27 you say.
27, my lord. 15 to.
I hear
my
you.
lord. I will place my facts separately.
my lord,
ফেরত দিয়ে দিন ওনাকে
Lord,
ওটা ওনার কপি একদম উপরে যেটা আছে ওটা ওনার কপি ওনাকে ফেরত দিন এটা কি
I have received.
ওটা না একটু
I have
একদম
received.
বাঁহাতে যেটা আলাদা রাখা ছিল
I have received.
দিয়ে দিয়েছেন
পেয়ে গেছি।
lordship pleasure was to fix it on
21 তারিখ
21st
মার্চের
March.
can it be 22 because 21st one matter is fixed. My lord, from long back
Very well, 23, yes.
20. This is March, in March. Oh, 22 March. March. Then 21st March is no problem, my lord.
21st March.
My lord.
Yes.
Yesterday, daily this similar point of law, my lord, RTR has also directed to appear these matters together. My lord, item number 857 to 859, yes, from yesterday's list, man. But it is now it is splitted. It is appearing as item number 856. It was appearing as
Same issue.
same.
দিদি এই নাম্বার গুলো নিয়ে নিন, এইগুলোর সাথে ওগুলোকে রেখে দিন। They are hearing matters.
Hearing matters. Or it can be appeared on the same day, my lord. Convenience for the
Or it will be difficult because hearing matters are taken up on Mondays and Wednesdays. Let them remain, let us see. Because once these are disposed of, I'll
Yes,
pick
that
up all
those
matters.
matters can also be
Absolutely,
disposed.
yes. Same order. Till 33, same order.
Except 21 and 22.
These are different issues.
These are
Till 20, same order.
27 I appear.
Till 20, same order. 21, 22 are
Till
different.
20.
20 I'm
Call close. 20 of the same order.
and again from 23 to 30.
আস্তে আস্তে সবাই মিলে বললেও আমার মুশকিল হয়ে যাবে, কনফিউজ করে ফেলতে। অনেক বলতে দিন, আমরা করে দিচ্ছি।
22, 21. Sorry, 21.
Item number 21, I picked.
Item 21, last year the date has to file report in the form evidence. It is affirmed. The annexure is not in order. And it is not today.
Not today.
Only not today, my lord, because already, my lord, National Highways Authority, they have filed their report, my lord. They have specifically stated what is my grievances, my lord, that has been redressed, but no document has been annexed to that report, my lord. So for that.
So he is coming back with a further.
Yes, my lord.
Because only date has to take instructions whether the arbitral award has been calculated by the competent authority or not.
Oh, it's that issue. Yes.
I shall file my report.
Not today.
Yes, not today.
Didi, not today.
Not to Didi.
22.
22, my lord. But I am for the respondent. Respondent Port Trust, man.
For last 60 years, the possession has not been taken over the land. Even the compensation has not been paid.
Service complete.
Service is complete.
My lord, state respondent, I am not appearing for the state respondent.
My lord, today, my lord, I am praying for a direction for short affidavit. Because I have made allegations which is required to be, my lord, addressed by the state. First of all, the property was made.
Take a call.
Pardon?
The petitioner cannot call for an affidavit. Let the state take a decision.
My lord, my instruction, this, my lord, this issue has already been decided up to the division bench. Short point, my lord, my learned friend will say what is his grievance.
You are appealing.
Kindly look at my prayer.
Once more, I am for the land belongs to the Port Trust.
There is the service on the state. State.
There is every service.
Volunteer Development Authority.
I'm only for the Port Trust.
All have been served.
Yes. No, yes, no. I am for the respondent number 2, and 3. I am for the respondent number 2 and 3. My learned friend has filed an application for recalling upon an order. Yes, admitted.
I do not suppress anything. I always admit anything, whatever I do.
নামটা দিন।
State, can I request someone to appear? Mr. Dev. Please serve a copy to Mr. De. Because you've served and no one is appearing. Yes, please place your place.
Kindly come to my prayer in the writ petition. I am praying for quashing of a order passed by the estate officer under the Public Premises Eviction of Unauthorized Occupants Act in respect of the land not in possession was never given to the government, not taken possession of the government. And Port Trust had proceeded to the, for a shortcut method, my lord, proceeded to the estate officer to take an order ex parte against us, and order has been passed for giving delivery of possession with the police help. But that was wanted to be implemented by filing a writ petition also against us without making us party, and police help order was taken for which, against which we have prayed for an application for recalling. That is pending since the judge is not sitting singly, it cannot be listed. My lord, kindly look at the order of the estate officer at page 88. It was under subsection 1 of section 5 of Public Premises Eviction of 1971.
Learned counsel says that this issue has been dealt with.
What I'm saying short, very short. Initially, the land was acquired by the state of West Bengal. It was handed over to the Port Trust for the development of the Haldia Dock Complex. We have taken possessions. Some outsider, including the petitioner, they have encroached upon the land. Then I took out an application, writ application before this honorable court to identify those are the encroachers. Honorable Justice Joymallo Bakshi was pleased to pass an order, identify those persons by the district magistrate. He will file a report. He has identified this petitioner in respect of the plot who are in possessions. And thereafter, Honorable Justice Joymallo Bakshi was pleased to direct us to initiate a proceeding under the Act 1971. Accordingly, we proceeded under the Act 1971. Thereafter, Mother Estate Officer passed the final order of eviction. Then we could not implement the eviction order. Then we filed an application before this honorable court for implementation of that. That matter went up to the appeal court. Appeal court says, no, you have a provision for statutory appeal. You go and appeal in accordance with law. But in the meantime, their statutory period is over. Somehow somebody has prepared an appeal. I do not know my learned friend has prepared an appeal or not. If he has any grievance at all against the order passed by the estate officer, his statutory remedy under section 9 of the Act 1971. Instead of that, he has filed a
While property has not been acquired, not been taken possession of till today, 50 years have passed. We have the resident.
50 years now he is coming.
No, you have attacked my property. That's why I have.
No, that is not correct.
Municipality certificate,
statement.
my tax receipt, my porcha,
Whatever
everything is there as a matter record.
That you can place before the appellate forum.
Appeal, my lord,
Where should I place it?
Lord,
I have not been made party. I have filed out a writ petition for the purpose of protection of my possession over the said property, where I am there for 50 years. Without noticing me, my lord, this has been done.
You have already been held to be an encroacher.
No. I have not.
I'll see one paragraph. One paragraph.
Behind my back. Where it has been held. Whatever the port, what the Port Trust has given, my lord, as a matter of course.
Challenge the order of the coordinate bench.
Coordinate bench order I have for recalling. Prayed for recalling of the order where protection was given by this court. Recalling application is pending till today. Kindly look 2-3 pages of my petition. My petition I will not take your lordship to the averment. Lordship see to the documents.
Carried till the division bench.
Not myself. I did not carry.
In respect of that land, whoever they have filed.
My
they were party in the writ petition.
My appeal is pending before the division bench. Still pending. Against the order directing that position should be given. Physical position. But in which the proceeding I was not made party. Calcutta Port Trust is surreptitiously wanting to evict me from the property where 50 years we are.
Still have a right to appeal, sir.
I have a right to residence. I have right to property.
And not a right to appeal?
Right.
What, against which I shall prefer appeal?
Two appeal is
Against which order?
Against the order against you?
Order not against me. I have not been communicated with any order.
The encroachers. An eviction order.
I have not. Encroacher must be a person whose title has lost. He must have encroached. I cannot encroach in my own property.
The prima facie, I don't think.
Lordship,
this
kindly
is
see
the-
paragraph six. Paragraph 6 of the order,
Prima facie, I shall
Only your Lordship, kindly see paragraph
look at my
6.
petition. I am the petitioner.
Paragraph
Kindly
six.
look at my petition for once. What the case I am made out.
He's challenging maintainability, so he has the first right of audience.
Yes.
Maintainability.
Maintainability, yes. First
He
of
has
all,
not said the
yes,
maintainability.
maintainability. Obviously, maintainability. First of all, he did not prefer an appeal under section 9. Second, he did not challenge the order passed by the learned single judge. Third, he has not challenged the order of the division bench.
Let him disclose all the orders.
Here and now, I am disclosing.
Give me the copies
He
of the
knows,
orders. What
he
you are
filed an
saying so.
application for recalling. He doesn't know what is the order.
That is an order for police help you have taken from the Honorable Justice Joymala Bakshi. That is the only order against which I preferred an appeal.
So cause notice was issued. He did not appear. The eviction order was passed. He did not prefer an appeal under section 9.
Poor villagers' own property.
And poor villagers,
Family
50
is
years,
staying
60 years.
there.
This story will not.
You are recorded owner paying tax. Municipality
story
has
will not
recorded us our ownership. Municipal tax is being paid by us. Haldia, Calcutta Port Trust, Haldia has never come forward to take the possession of the property for 50 years. Now, all of a sudden, they rise
Lord
from
Sukali, see the section 9 of this act, man. Lord Sukali, see. Section 9. Yes. Section 9, he did not challenge the order of single judge. He did not challenge the order of the division bench.
Was served upon the petitioners?
Yes.
No.
My lord, notice was
Let
served.
them
They
show.
appeared before the division bench, single bench.
No. I challenge the order suo moto.
Will
No,
you
no.
come back with a short report in the form of an affidavit?
Well, I shall file an affidavit, not short report. I have to disclose all these orders, everything I have to.
Please do that.
The so-called notice he has annexed.
Please take this.
He has
back, come
annexed
back-
to the
come
writ
back-
petition.
Come back with evidence.
He is saying that no notice has been served. This is the notice.
Let affidavits be filed. Several factual disputes. Affidavit of service. None appears for the state respondents despite service. Please serve a copy to Mr. Dev.
না দিলে আমি তোমাকে দিয়ে দিলাম
ঠিক আছে ভোটটা বড় লোক আছে আমার মুখে
Mr. Dev is present in court, regularized.
চতুর্দিকে মামলা করছে
Copies of the direction thing. Paragraph.
নাম
Learned counsel for the
না দেবে না
জেরক্স করে দিয়ে দেবো
Kolkata Port Trust seeks to use an affidavit in opposition in this matter. Paragraph upon consideration of the submission made on behalf of the parties, this court is also of the view that the matter needs to be heard on affidavits. Paragraph
keeping the point of maintainability.
affidavit in opposition be filed within 2 weeks.
No, 4 weeks. 2 weeks it's
4
not
weeks
possible.
from date.
I can draw that within 2 weeks, no problem. But
Stop affidavit in reply, if any, be filed within a week thereafter.
2 weeks.
Within 2 weeks thereafter. Paragraph, let the matter go out of list for the time being. Stop liberty to mention.
state the-
Paragraph, the issue of maintainability is kept open.
maintainability,
4 weeks or 2 weeks.
maintainability point be kept open. Because otherwise they will say no, at the point of
No, maintainability point is always there. Merited thing.
no, that is a decision. If I not take it now, it will be difficult for me later.
Next.
8 তারিখ না
Join.
My lord,
23 to 33, the same order will be passed.
It's 642 minute. I am for the petitioner. I am filing the affidavit of service.
He has paid for early disposal of the appeal which is pending before the divisional commissioner. We have no objection if your lordship
Innocuous
can.
prayer.
Yes.
Very innocuous prayer, isn't it?
My lord, the appeal was filed on 28th of March 2023. Almost 1 year have passed and my lease is going to expire on 28th of March. 28th of March of this year. Your lordship kindly give a direction for disposal within 2 weeks. Otherwise, everything will become infructuous.
Appeal is before the district.
Divisional commissioner.
Respondent number 3.
3.
kindly come to page 24. That is the date of filing the appeal, 1st March 2023.
Page?
Page 24. That is the forwarding letter by which my memorandum of appeal was filed. It was received on 1st March 2023.
Let there be an order within 2 weeks.
Yes, madam. Have no difficulties. It is for the S1 number 2.
The petitioner
না ডিরেকশন আছে জি এর উপরে আমরা হচ্ছে S1 number 2
preferred an appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules, 2016, before the Divisional Commissioner, Burdwan, being the third respondent herein. On 1st March 2023, which is yet to be considered. Stop. The innocuous prayer of the petitioner is for a direction upon the third respondent to dispose of the appeal within a stipulated time frame. Paragraph. Upon consideration of the submission made on behalf of the parties, the petition is disposed of, directing the third respondent to consider and dispose of the appeal within 2 weeks from the date of communication of this order in accordance with law. Petition disposed of or disposed of policy. There should বাকি 3 line code. However, no orders to cause since no affidavit or agency records. Dispose of দুবার বলা দরকার. Next.
Petitioner led by Mr. Pankaj Halder. The petitioner applied for the short-term mining license of sand.
Give me a minute.
In the same same cause of action, in earlier order has been passed for your law. This is the order. Ability of the service. Madam, your lordship has already been passed the.
Have you served the mineral development?
Yep.
No.
Yes, have you served the mineral development?
Mineral Development Corporation.
Where is the service? No copy is served. I do not find. That's why I'm asking. Where is the service on the mineral development? Yes.
This is the evidence of service, right?
Please show me. Did they in photo?
Similar কি জানবো কি সেটা কি আছে
ফাইলের মধ্যে লাগানো আছে ফাইলের মধ্যে ফার্স্ট সেকেন্ড থার্ড এর মধ্যে ফাইলের মধ্যে পিটিশনের মধ্যে লাগানো আছে
Yes, where is the service?
Please come to page 26.
Please show me. Mineral development.
আরে হোটেলকে কপি সার্ভ করেছো মিনারেল ডেভেলপমেন্ট কর্পোরেশন কে জজ সাহেব জিজ্ঞেস করছেন সেটা চাইছেন জজ সাহেব দেখতে চাইছেন
Copy has not been served to them.
Then
well a repetition is not maintainable it's misconceived itself.
Why?
Well the petitioner applied on third by post. The respondent authority received on fourth. A repetition filed on 9th. That is the inaction on the part of the respondent.
This one.
This one, your lordship kindly turn to page 22. This is the application, my lord, which is sent. There is a postal endorsement sent on 3rd, page number 22 of the application. Next, my lord, your lordship kindly turn to page 29. Received on the authority received on 4th.
21, my lord, which is Treasury Challenge on
3rd.
2nd January 2024.
2 তারিখে তুমি ট্রেজারিতে রিজার্ভ ব্যাংকে টাকাটা জমা দিয়েছো, 3 তারিখে অ্যাপ্লিকেশন করেছো, 4 তারিখে অথরিটি পেয়েছে, 9 তারিখে
And 9th you filed the writ petition.
9th.
The
Affidavit
authority
portion,
has
my
only
lord.
one application to decide, that is only yours.
Go through the.
Yes.
Yes, ma'am.
Dismissed as premature.
No, my lord, this is a similar.
Firstly, you have not served the mineral development.
My
You
lord,
did not bother to serve.
no, my lord.
Secondly, the authority receives the application on 4th January. You file the writ petition on 9th January. So the authority has no other work, only your writ petition, only your application to dispose of.
So my lord, that part your lord, I leave it to your lord.
Withdraw. What? I'll dismiss it as premature.
No, my lord, kindly liberty to file a press withdraw, my lord.
What is this?
No, my lord, this my lord, pen has filed. I have not this. My lord, Julian was.
Very conveniently, you shifted to your.
No, my lord, no. This is not my. Kindly see my name. Just my lord, I admitted my lord.
I think the senior should take the responsibility.
No. I have not seen even my lord today the brief. My lord, I am paying for.
Learned counsel for the petitioner. Let them
এই হচ্ছে তো মুশকিল
seeks to
naturally
withdraw the writ petition on the ground of certain defects detected therein and seeks further liberty. Counsel na kore, the petitioner kore. The petitioner seeks to withdraw and seeks further liberty to file a fresh writ petition on the same cause of action. Paragraph in view of the above, the writ petition being WK such and such is dismissed for non-prosecution. Paragraph liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph there shall however be no order as to costs as in certified website copy. Filing, mentioning everything within 1 week.
I have not made sir.
And so early, so urgent.
আমি করিনি মিল স্যার
কি urgent?
কিছু urgent
644.
My lord, I am for the petition.
Service.
Yes. Service has been effected.
Well, this is second round of litigation, my lord. Earlier occasion, my lord was pleased to pass order, my lord, by directing us to file a comprehensive representation before the authority concerned, my lord. That was filed and that was considered and our prayer was rejected, my lord.
Force majeure ground.
Yes, my lord. That is the issue, my lord. 6. May I place the order impugned?
At page?
My lord, at page
prior to he placed the order, this is appealable order, this is a provision of appeal before the. Yes.
Where is the order page?
My lord, in that event, my lord, kindly waive that limitation, my lord.
Yes, I am not standing in the way of limitation.
My lord, that is at page 115, my lord.
That will be condoned and recorded.
Yes, my lord.
It's the ADM's order.
Rule 51 of West Bengal minor mineral concession order থাকবে ওটা।
The order passed by the additional district magistrate and Tarak affidavit service. Additional district magistrate and district land and land reforms officer, Jhargram, on 24th January 2023 is assailed in the writ petition. Paragraph, the said order is amenable to appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules, 2016. Paragraph, the petitioner seeks to approach the appropriate forum by filing a statutory appeal. Paragraph in view of the above, the action is dismissed for non-prosecution, dismissed as not maintainable. The writ petition is dismissed, being not maintainable. Liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, in the event the petitioner prefers the statutory appeal within 2 weeks.
2 weeks.
Within 2 weeks from date, the appellate authority shall consider the appeal on merits and not dismiss the same on the ground of limitation.
Grateful.
There shall, however, be no redress to costs as notified of said.
Grateful. What is this?
Wait, please, Your Lordship. My Lord, I appear on behalf of the petitioner. My Lord, my renewal application for long-term mining lease, my Lord, was initially rejected. My Lord, it was rejected on the ground that under the 2002 rules, I have made the application. In the meantime, the 2011 notification had come into effect. My Lord, hence my application, my Lord, would not be considered. Challenging that, my Lord, I came before this honorable court. But this honorable court, my Lord, held that the 2011 notification, it has been held to be ultra-virus, has been struck down, and the application having been made under the 2002 rules has to be considered in terms of the 2002 rules. Lord, a point was taken that my application was short by 2 months. Lord, it has to be made within a period, Lord, 6 months in advance. I made it 4 months in advance. Lord, the honorable court observed that this was not the ground taken in the order of rejection and hence could not be taken. This is, my Lord, well settled principle. My Lord knows, my Lord, that an order passed by an administrative authority will be tested on the anvil or the order itself rather than on the basis of any subsequent reasoning. My Lord, 1952, my Lord, Constitution bin Govardhan Das Banji, my Lord. The respondents, my Lord, have passed the impugned order. My Lord, here they have, my Lord, said again that it is short by 2 months. And also taken into consideration that the 2016 rules have come into effect. That, my Lord, in my respectful submission is surplusage because the honorable court in the earlier round of litigation has confined the scope of consideration only to the 2012 my Lord, rules. That means 12.1. So I admit that it is short by 2 months, but then that issue, my Lord, the respondents are stopped from taking. My Lord, I take, my Lord, to the first order of rejection, which is at page 82. A very short order, a decision rather. This is 14th March 2012 at page 82.
Yes.
Owing to the non-applicability of Rule 5 to Rule 16 as per amended provision of the 2002 rules, which has come into effect from 5/12/2011, published in Kolkata Gazette in case of grant of mining lease in respect of riverbed materials, so and so, which will be governed by the Rule 16B and shall be granted through public notice. Hence, the guidelines of the government dated 21/2012, his application for LTML has been considered and rejected. This was a subject matter of challenge. My Lord, the order, my Lord, which was passed by Justice Sengupta, my Lord, is at page 104. It starts at 104. Lord, I take, my Lord, directly to page 110.
Yes.
Paragraph 7. Be that as it may, if the question of extension of mining lease is adjudicated under the provisions of the 2002 rules, then it would be governed by provisions of Rule 12.1. The provision had not been struck down. The said rule provided that an application for renewal of mining lease shall be made at least 6 months before the date when it is due to expire, but not before 9 months. This provision is also reflected in the lease deed. But in the instant case, although the date of expiry of mining lease was 7/12/2011, the petitioner filed the renewal application on 5/8/2011, that is about 4 months before the expiry of mining lease. Thus, as contended by the respondents, the provision of Rule 12 was also not complied with. Therefore, on this score, the petitioner may not be entitled to renewal of lease. This was respondent's submission. Then, paragraph 8. However, this is not the ground on which the impugned order of rejection was passed. The impugned order has to be adjudged on the reasons cited therein, and these cannot be supplemented by fresh reasons provided by the state at this stage. Moreover, in exercise of its powers under Article 226, this court ordinarily would not substitute the reasons or supplement the reasons. The impugned order cannot stand. It was based on the amended provisions of 2011 that was purportedly declared ultra vires by this court, as discussed earlier. The impugned order is set aside. Matter is remanded back to the ADM for fresh consideration after hearing the parties within 6 weeks from the date.
So it was an open remand.
It was an open remand, but with an observation that will not this delay in making the application within the period of 6 months to 9 months. I was shorter by 2 months.
This delay part was not taken into consideration in the earlier order. So the court restricted the respondents from dealing with it in the writ petition. There was no restriction on the respondents to deal with it in the subsequent order.
My lord, with deepest of respect, my lord, if I
read the lines.
My lord, paragraph 8.
Paragraph 8.
My lord. However, this is not the ground. However, this is not the ground on which the impugned order of rejection was passed.
Yes, so that it was not dealt with in the impugned order.
Yes, and then
Delay part.
yes. Now then, the impugned order has to be adjudged on the reasons there cited therein. These cannot be supplemented. Now, my lord,
by fresh reasons provided by the state at this stage.
Yes.
At this stage means during hearing of the writ petition.
My lord. Moreover,
the state took that point on during hearing of the writ petition. The
My
court
lord.
said no. You have to rely only on the grounds taken in the impugned order.
My lord.
Not beyond that.
My lord. Now, my lord,
There is no restriction on the authority to deal with this.
my lord, twofold, my lord. My submissions will be twofold. One, my lord, I admit that, my lord, it is shorter by 2 months. And two, my lord, kindly sees that, my lord, law was in a flux at that point of time. My lord, there were notifications coming in. We said that renewals would not be granted, would be granted. My application was pending. Now, this, my lord, it caused some, my lord, delay, and the delay is negligible. Because the time span provided for in 12.1 is, my lord, between 6 to 9 months. I cannot apply at any date, my lord, prior to 9 months. I may not apply beyond 6 months. So this is, my lord, the window given.
Please show me the order impugned.
Yes. My lord, this is, my lord, at page, my lord, 120 it starts.
120?
120. But the relevant portion is page 122.
Lordship, may I just indicate one thing, Lordship, without going to, there is no scope of an interim order in this matter. Now, the thing is, the application submitted by the petitioner in terms of Rule 2002, subsequently 2016 rule came into effect, which makes it mandatory for grant of mining lease through auction only. So, as on date, without auction, no lease cannot be granted. And thereafter, in 2022, another rule has come into effect, which also makes it mandatory for grant of any mining lease.
21 policy.
Yes. So it was, the application was submitted in terms of Rule 2002.
The exception?
Because if the application, because if the thing is in that
application was pending.
Application was pending, but the application was not submitted within due time.
That has been now, Lord, considered, and Lord, this point was taken in this order.
It's not been dealt on merits. You have only dealt with the delay. Let us see the impugned order.
My lord. Lord, page 122.
Yes.
My lord, the second paragraph. Until here, my lord, he has dealt with the facts and the order having been passed by this honorable court in the first round. Now, if the matter is adjudicated under the provisions of West Bengal Minor Mineral Rules 2002, then the renewal of mining lease as per provisions of 12 sub rule 1, my lord, which is quoted. My lord, I skip over then. But in the instant case, the date of expiry of the mining lease was 7/12/2011, and she filed renewal application on 5/8/2011. That is before 4 months of the date of expiry of her mining lease. Thus, the provisions of Rule 12 of the Minor Mineral Rules 2002 was not complied with. Moreover, the said provision was also mentioned in Part 8 under page 24, paragraph 4 of the mining lease deed of the writ petitioner. So, in this court itself, the application of the petitioner cannot be entertained.
There are other grounds also.
Other grounds, my lord, were, my lord, not directed to be, my lord, considered by the learned single judge in the first round of litigation. The scope, my lord, is confined to this. Because, my lord, the Honorable Court said that nothing anterior to 2002 rules or which comes later would be applicable in respect of the application which is made under the 2002 rules. 2016, 2011, both were, my lord, dealt with in the arguments, my lord, in the first round of litigation, my lord, I showed to your lordships. Even 2016, my lord, was referred to. But his lordship, my lord, was of the view that since it was made under 12.1, it should be considered under 12.1. Insofar as 12.1 is concerned, my lord, I am short by 2 months.
Under the new rules, my lord, the pending application shall become ineligible. That has also been considered, one of the grounds, apart from the fact that the application was filed, my lord.
But does the new rule say so?
Yes, my lord. Rule 16 has been quoted. Kindly see page 123, my lord. Rule 16, Rule 61. That is one of the grounds. 123, second paragraph. Moreover, the West Bengal minor mineral concession rules came into force wherein under Rule 62 of the rules was repealed. Moreover, as per Rule 61 of the minor mineral concession rules, declaration of ineligibility of the pending minor mineral applications for mining lease, including the application of reclassified major minerals, all application for mining lease of minor mineral, including reclassified minor minerals, by its number so and so, received prior to the giving effect of this rule of its pendency shall become ineligible.
Rule 61 and specifically Rule 61.
The rule is not.
Kindly consider Rule 61 as well as 62 of 2016 rule.
I have the book.
আমাদের আছে।
The exception is also there in the proviso, provided if the applicant has been issued a grant order or letter of intent or any other government order requiring the alteration of applicant's position, then his mining lease application may be considered after due compliance of all necessary conditions. Apart from these, all other applications became ineligible in terms of this rule.
What about the second proviso to 62? The exception?
Exception, Rule 62, notwithstanding such appeal, anything done. Here, Lordship, nothing has been done. Any action taken or any prosecution started under the said rule shall be deemed to have been validly done or taken or started as the case may be under the corresponding provisions of these rules.
Covered by
my understanding, this, according to my understanding, his case does not fall within
anything done.
Provision.
It falls within anything done.
But with regard to applications for mine lease, it's very clearly dealt with in Rule 61.
61.
There is undoubtedly a grey area.
Yes, my lord, I admit that.
Action is not an action taken. Application filed will not come under the definition, purview of the words action taken.
And my lord, kindly sees,
taken by the authority, not by the applicant.
But then, my lord, an order
done is a blanket term.
Yes, and then, my lord, the court, my lord, has passed an order to be considered. Now, today they take a point, which is, my lord,
they have considered 12 too. 12.
They have considered 12. Now, today, my lord, the point being taken is, Lord, 61 has come into effect. Hence, the application.
And may we come back with a report, my lord?
No renewal can be granted.
Because
the point is that no renewal can be granted in terms of 2002 rules in view of 61. So 2002, my lord, would not be given effect. This,
if we do not take that into consideration, Section 12 is also very good.
Lord, but kindly see, my lord, 62, my lord, the rider, anything done. Yes, 12.1.
Rule 12.1, you are short by 2 months.
Lord, I agree, my lord.
So it should be the discretion of the authority. The court cannot insist.
Well,
it's a rule.
True, Lord, I admit that.
Court cannot insist on violation of the rule.
No doubt about that. Lord, no doubt.
Your case, I'm afraid, is weak. Let them come back with a report.
My lord.
Even if the first issue is, the second issue is not taken into consideration.
My lord.
I
follow. I follow.
Regarding the first issue,
I follow.
Who will come with the report? Both?
Both of us. Both of us. May I take a lordship's leave? Our matter has been called.
The order passed by the Deputy Presidents. Passed by the Additional District Magistrate and District Land and Land Reforms Officer. This is not appealable.
No, Lordship, this is not in terms of rule 2016, it was 2002.
2002.
Earlier,
Additional District Magistrate and District Land and Land Reforms Officer, Purva Bardhaman, on 13th June 2023, turning down the prayer of the petitioner for renewal of long-term mining lease has been challenged in the writ petition. Paragraph. Learned counsels for the state and the West Bengal, and the West Bengal Mineral Development and Trading Corporation Limited seek to submit reports in the form of affidavits in this matter. Paragraph. Let the matter appear under the same heading on 13th March.
I'm grateful. Lord, in the meantime, Lord, let them not put it to auction, otherwise my writ petition becomes infructuous.
Sir, a very weak case. I cannot pass an interim order in this matter. It is absolutely the discretion of the authority.
13 years has been passed. His lease expired in 2011.
For 13 years, if they have not done so, my Lord, I was praying.
I hope they'll not do it in the next 2 weeks.
Yes. I'm grateful, my Lord, deeply.
Next.
I appear for the petition in this matter. The yesterday matter was taken up by your lordship.
Your Lordship, Mr. Supratim Dhar appearing on behalf of the
I had a
citizen
talk
begged
to
that
him
some
also
other-
personally. He said that my junior will be there. I am to follow the order of Justice Horidas Das. That is a part of the petition. Kindly take the matter for once.
Your Lordship,
Petitioners-
begs in some other court. Kindly, I'm praying for not today.
Yesterday also, not today, was given.
But let us not embarrass our junior friend. Please come back. I'll give you a short date.
Come at.
Let us not embarrass our junior friend. Please come back. I'll give you a short date.
I am coming back days in and days out. The third day, my lord, they are not there. If they choose not to contest, it is not a case for contesting even.
30th November, it was on prayer of the petitioner that it was.
Because the document they could not produce. Then I said that I shall be giving the document.
Please do not make such submission. On prayer of the respondents, the matter is adjourned. Paragraph. Let the matter appear under the same heading. 29th February.
29th.
February.
In the same heading, in the same heading in the same.
It cannot be the same on the second date.
May it be as to be mentioned, Lordship. Well, keep it manner for that day so that I can get a turn.
Same heading. Same heading.
Same position written kore jano. But position will not be retained. I have got this turn, my lord, after a long time.
Same heading, short date, same. What else, Mr. Bhattacharya?
It will be disposed of.
Done by the system. It will be disposed of under mentioned matter.
Again, the matter will go down in the list. I am not at fault. 2 days, my lord, consecutively. I am
under the heading mentioned matters. That's why.
mentioned matter, my lord. It was mentioned matter for long time. It was under the mentioned matter. Thereafter, I got the turn. Now, new matters will be there above me.
Let us see.
May it be only with the marking date, adjourned till that date. But Lordship can be marking.
Yes, I've adjourned till that date.
May it retain its position at least.
Let us see.
I am appearing for.
I'm submitting affidavit of service, my lord.
Where is your service?
Lordship, I beg to appear for the petitioner, my lord.
For the
petitioner.
Yes.
I am appearing for the respondent number 4, 6 and 7.
You are appearing for
4, 6 and 7.
4, 6, and 7. What about 5?
Lordship, five have been served, your lordship.
Give you a minute. Yes, served.
My lord, the matter relates to removal of illegal and unauthorized encroachment from PWD land, my lord. The petitioner herein made a representation before the state respondent number 3, who is the assistant engineer on PWD Road, Kontai Highway Subdivision.
Where is your representation?
My lord, at page 29. Page 29, annexure P2.
Yes. Anything for the anyone? Do you want to say anything for the private respondents?
I'm for private respondent number 467.
Mr. Submission.
467.
467.
Do you want to
Yes.
make any submission?
Yes, my lord. I am the temporary tin or asbestos set gumti and
That is unauthorized matter.
the lordship, these private respondents are permanently residents of Kanchgaria village, and your lordship, your petitioner is permanent residents of Kishon Nagar. The land in each question is Kazragaja. Recently, your petitioner come here by virtue of deed, and
It's not your concern at all. Anything to do encroachment? Do you have
no,
any-
there is no encouragement. There is a more than 800 feet vacant land in the southern portion of the land of
Do you have
petitioner.
a shop in your own land? In your Raiti land?
No, my lord, I am in the PWD land.
You're admitting that you're in the PWD land, right?
Yes, my lord.
I record this.
Madam.
You'll be given an opportunity of hearing by the authority. You will be given an opportunity of hearing by the authority. Place all your documents there, okay?
Yes, my lord.
Affidavit of service. None appears for the fifth respondent despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon PWD land in adjoining his plot, comma, thereby obstructing his use and interest. Paragraph. No, actually, the petitioner submitted a representation before the concerned authority in this regard on 18th August 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that the third respondent is directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such as within 3 months. 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of.
Grateful to your lordship.
Thanks.
I'm for the
Item number 648, my lord, Ms. Sushmita Sadati appearing, my lord. She is very sick, my lord. She is unable to court to today court, my lord. I am paying for only not today, my lord. She is very sick, my lord.
Notice has been served upon all.
My lord, yes, I received the copy, my lord.
You're appealing for whom?
My lord, Union of India, my lord.
Have you served the private?
Upon all, yes, yes, madam.
You'll-
Service has been affected.
Let there be a short adjournment.
My lord.
On prayer of the Union of India, the matter is adjourned. Paragraph, let the matter appear under the same heading on 1st March.
My lord,
1st March.
first month. In the same heading.
Motion. Same heading
Well-
cannot appear every day.
Yesterday he was absent. Today also he is absent. But
Heard that
I will suffer, my lord.
sample.
My lord, kindly under the heading to be mentioned.
All the matters cannot be under.
But this is not my fault, my lord. No fault on my part.
All, sir, that I'm
No,
not
my
able
lord.
to grant
Kindly,
dates to you.
kindly, my
What
lord.
dates?
My lord, kindly fix this matter under the heading.
Next matter. 649. Oh. 649. Anyone?
My lord, in this matter, my lord, in this,
49.
649.
my lord, in this matter, Mr. Trivedi is appearing, my lord. We have instruction, my lord, if it can be fixed on any other day, lordship.
These are mentioned matters, sir.
Analogous matter.
48 to 52.
Analogous.
Analogous matter.
48 to 52.
52.
Yes,
Let the same order be passed. Come back on the next date. I will not grant any further adjournment.
But under the heading to be mentioned, my lord.
Motion.
Much obliged.
Well, I am for the writ petitioner, my lord.
নেই তো কেউ advocate.
None appears for the Union of India. None appears for the respondents. কোনো respondent আসেনি। না, ওটা বড় দরকার নেই। None appears for the respondents. Let the matter appear under the heavy motion. সবগুলো। আগেরটা same বলে সেটা motion। এটা আগেরটা। এগুলো সব motion। Next.
Well, I am for the writ petitioner, my lord. Encroachment in my
Matter, I am for the respondent number 9 and 12, my lord.
my lord, in front of
You are for
page,
the petition.
petition. Page number 25, my representation, 25 and 20.
For that service.
Yes, yes. After service of notice, my lord, I have served and
Where is your affidavit of service?
I am for the only respondent number 9 and 12, my lord.
yes.
My lord, this is also misconceived and suppression, my lord.
Please give me some.
Yes, my lord.
Mr. In the state, my lord, I think I have served notice to the state, my lord. Mr.
Where
Owen,
is the affidavit of service?
yes, I have given. When a private respondent appearing, my lord.
Okay, I am for the only, my lord, 9 and 12, not for others, my lord.
Yes, please give me a minute, sir.
Mr. Owen Manaji appearing for the state, my lord, I have served notice. Upon notice, my lord, I have mentioned, my lord.
You are for 9 and 11.
11, but 12, my lord. 9 and 12.
9 and 12.
12, my lord.
উল্টো পাল্টা হয়ে গেছে এদিকে রেসপন্ডেন্ট সুকান্ত এদিকে আসো তুমি পিটিশনার নাম উল্টা পাল্টা করে দেবো নাম দাও নাম উল্টা পাল্টা করে দেবো
My lord, I have made representation, only consideration.
1 minute.
Nine and 12 হয়তো আন্দাজে
No one is appearing. Mr. Banerjee.
Yes, for that.
অনুভব একা একা
Already done.
Yes, my lord.
My lord, I am denying, my lord. Firstly, my lord, it is a misconceived one and suppression, my lord. My lord, may I, my lord, because they have filed a, my lord, preemption case before the court of the learned municip.
In respect of which property?
In respect of, my lord,
PWD
plot,
land?
no, plot number 5. In
This
that,
is in respect of PWD.
no, my lord, may I submit, my lord. The Sobong Mohar Road is adjacent to the, my lord, plot number 5
Yes.
in Mauja Katina. And the petitioner has no share in respect of, my lord, plot number 5.
This court cannot decide. Next.
My lord, for getting, my lord, one, my lord, transfer was made. Praying, my lord, they are claiming they are the adjoining holder. They are the Batta plot. And for that sale, they have filed a preemption case stating that as they have no share in respect of plot number 5, so for their ingress and egress, that land is very much required, my lord. We are, my lord, made, my lord, tin shed advested upon our land, my lord, that is the plot number 5. My lord, kindly see the, my lord, plot information slip, my lord. My lord, plot number 5. My lord, they have stated the PW land is adjacent to the plot number 5 in their own writ petition, my lord. Kindly paragraph number 5, my lord, in their writ petition.
Yes.
This is Bata plot, my lord.
They are the owner of Batta plot. We are the owner of the plot number 5, which is adjacent to the, my lord, PW road. And I have, my lord, this is our, my lord, plot information. In respect of plot number 5, which is adjacent to the PW road, they have no share. As they have no share, for getting the, my lord, certain portion of the land,
they have filed a preemption case. In that case, my lord, I have bring the plain. They have stated as they have no share in respect of the plot number 5 for ingress and egress to the my lord PW road. That portion is very much required, my lord. They have not stated in the writ application this is a suppression. Misconceived one because they are the owner of plot number Bratta plot, but they are plot not adjacent to the PW road. Our land, which is the recorded owner, we are the owner of the plot number 5, my lord. And they have stated in their writ application, paragraph number, my lord, 4, the 1 decimal of land out of the plot number 5/5 for Mauja Katina police station Paschim Medinipur was acquired by the state of West Bengal for public purpose. Major portion of the plot number 5 Mauja Katina was acquired from the Madan Mohan De and brothers. After the death of Dhirendranath Bera, his son and daughters, including the petitioner and their legal representative, inherited the aforesaid, including 21 decimal of plot number 5/541. Mauja, they are the daughters and sisters, my lord. But they have not the owner of the plot number 5. They are the owner of the plot number 5/541, which is not adjacent to the PW road. We are the, my lord, owner of the plot number 5, and just I hand over the tip. Moreover, as they have no share, so they are challenging one, my lord, transaction, file a preemption case. Stating, my lord, may I hand over the plain, where they have stated they have no portion to for ingress and egress to reach the PW road. For this purpose, this portion of the land is very much required.
Documents on the, you have a case. Please show me the documents on the next.
My lord, my lord, my lord.
Because the deed doesn't show any boundary. No.
Boundary, my lord.
No.
I think you need to come back with a report, Mr.
My lord,
An
inquiry should be.
It's not as innocuous as it looks.
My lord, this is there.
My specific case is adjacent to the road, my lord. Kindly see my application.
See that from your deed.
Kindly, that's why, my lord, kindly come to page 25. This is my application.
They may read anything, my lord.
It's not sufficient. It should be depicted from your deed. Your deed does not show that there is any PWD road around your property.
Yes, my lord. This is the.
Please come to the deed, page 16, 15, 16, 17.
Paragraph number 5.
Your preemption case says that there is a plot in between. And you have sought preemption of the plot.
That's why, my lord, the report may be called for, my lord. My specific case is that in front my P road they have constructed, admittedly, my lord. That's why, my lord, kindly.
Affected.
My lord, in case I address totally blocked.
Not blocked because you have, there is no pitch road in front of your house.
This is, my lord, another portion. My lord, kindly see this. Kindly.
Please come back on the next date.
My lord,
my lord, kindly see the.
Submit one thing, my lord. Well, who seek, my lordship knows it very well. Who seeks experience must come with clean hand. Their hand is not clear. They should mention it.
This is not.
Can I direct
copy of this on the next date?
Yes, yes, my lord.
Point number 4 is the BLLRO. If your lordship directs, he can do an inquiry, inspection also.
Yes, that's right.
My lord, that's why, my lord.
Please find out if you can find out with the documents. It's fine. Otherwise,
my lord, prior to that, consider that this is a suppression one, my lord.
Never not suppression, my lord. My lord, kindly see.
Come back on the next date. I'll consider yours.
My lord, my lord.
Please give me a copy on the next date.
I have already handled.
I'll keep this on record.
My lord, only consider the my lord under my lord. This is I have collected from the learned court below, my lord. From the learned advocate who is conducting the case.
Copy of
preemption case, my lord.
Copy of the plaint in this case 57 of 2022 and record of rights produced on behalf of respondent numbers 9 and 12 are taken on record. Tarage affidavit of service and none appears for respondent numbers. And none appears for respondent numbers 10 and 11 despite service. Paragraph. Learned counsel for the the learned counsel for the petitioners submits that the private respondents have raised unauthorized construction by encroaching upon a portion of PWD road adjoining their property, comma, thereby obstructing their egress and ingress. Paragraph. Learned per contra, comma, learned counsel for the private respondents submits. Number 9 and 12 submits that the PWD road is adjoining the Rayati plot of these private respondents and not that of the petitioners, for which the petitioners have filed a preemption case before the learned civil court, claiming preemption of a particular plot so that they are able to
engage in irrigation.
approach the PWD road from their plot. Paragraph. Learned counsel for the state respondents seek to submit a report in the form of affidavit in this regard.
My lord, may some mandatory point be kept open, my lord, as is the suppression of the fact, my lord.
Let the matter appear under the same heading on 7th March. Paragraph. The issue of maintainability is kept open.
Under the heading, my lord? Under the heading, my lord?
Motion. Under the heading motion. Lordship. My lord.
On the other side, division bench, item number 1, Mrs. Dunlop India versus Smith's Capital.
APO number 3, I am appearing for the petitioner. And my lord, in ACO number 4, I am appearing for the respondent.
You are appearing in the second matter.
My lord,
You are appearing in the second matter.
I am appearing in both. In 3, I am appearing for the petitioner. And in 4, I am appearing for the respondent.
It's only 1 and 2.
There are 2 matters, I think. ACO 3 and ACO 4.
SU 3 and SU 4.
ACO 3 and ACO 4. ACO 4 is, my lord, an application for impleadment by my learned friend. And my lord, the ACO 3 is my application for my lord modification of an order passed by the petitioner.
My lord, I appear for the appellant in this appeal. My lord, in ACO 3, I was to file my affidavit in opposition. But I am out of time, my lord, but I have prepared and served as well. But I am praying for leave for continuation of delay, and this affidavit can be taken on record.
Order sheet of
আমাদের কবে অবধি কবের মধ্যে দেওয়ার কথা ছিল? 18 তারিখ ছিল,
2
weeks বলেছিল। 18 জানুয়ারি মানে কবে? In the appeal, it is my appeal where this application ACO 3 has been taken out by one of the respondents, and then SEO 4 has been taken out by an intervener. But the appeal is mine.
The respondent in both matters.
Yes.
So you seek to file an opposition in both the matters?
Only in ACO 3. In the application by the ICICI Bank, I want to file an affidavit. There was a
modification, rather.
Yes, vacating of the order. But I was to file it by 1st of February. I'm out of time. Of 2nd of February, I'm out of time.
Commercial court, it's still pending.
Not before the commercial, before the company court.
In the company court.
Still pending, my lord.
It is just pending, my lord, for a long time.
Notices have been taken out and option is
Still disposal of the pending.
Yes.
The company petition.
So why don't you?
Well, I can understand, my lord, appreciate what is going to fall from your lordship. But in spite of what your lordship thinks, what I think your lordship thinks, but I am going to make my submission to your lordship that kindly hear it out.
So that's fine. I'll hear it out. But then, have you made any application before the company court for expeditious disposal or
no?
Since there's an interim order.
No.
The interim order.
And my lord, this order which my learned senior friend seeks modification or recalling of has been sustained in the Supreme Court. So now, my lord, so the order passed on consent on contest. The issues which are
but if your lordship looks into the division bench order, it is, my lord, it is an open-ended order. By way of an interim arrangement, that order was passed. My lord, leaving the liberty to my client to apply, my lord, before your lordship, my lord, for modification or vacating. It was just a tentative view that the court had taken.
No,
But
that
I shall make my submission.
order, but when the matter was disposed,
Yes, but it was made final. It was made absolute. Yes.
Absolute till the issue is decided.
Yes.
no such
By the company court.
Well,
Yes.
The lordship was part of that bench.
My lord,
Your
let
lordship
us not prejudge. We'll hear it on.
My lord, I am one of the petitioning creditors since the matter has gone in REM proceedings. I am also part of the proceedings which are pending in some other courts, but if these proceedings have not been served upon me, who are you? I am one of the petitioning trade carriers.
Trade carriers. Lord, what my learned friend is
This
saying.
marriage was a party to this appeal.
Well, they were
Not
party
to the appeal,
this
but my lord, in the
appeal.
winding up proceedings, my lord.
In the
In the winding up
company
proceedings.
petition, my lord, because your lordships know, my lord, once the company petition is admitted, it assumes a character in rem, my lord. All petitioning creditors.
This is with regard to variation of the interim order. That's
Related to properties of the company in winding.
right. Right.
So it
And
affects all
therefore,
the
it would, in your, if the application is heard and it would inure to the benefit of all the creditors.
So have you filed an intervention application?
My lord, in this case, this is not necessary because it's already a the proceedings are proceedings in rem.
Everyone has a right to be
Everyone
heard.
has-
Everybody has heard. Then the whole world will come before your lord. and say that I
No,
want
my
to
lord,
hear.
no, my lord, I am part of the proceeding whereas I had filed a winding up petition in the before the company court. When the company court admitted the winding up, all the petitioning creditors were made part of that proceedings. And therefore, I don't.
Well, may I just indicate to your lordship?
And
But-
I
well,
can
this
also
is-
file the application in respect of the instant property.
Well,
Well,
I used to
insofar as
appear.
my
Malad.
client is concerned, who has made the application, SUO number 3. My lord, he is not interested in the winding up proceedings at all. What has happened is this: a particular property in Mumbai, my lord, that is sought to be proceeded against in the company. I have come up with almost it is like an application pro interesse. I am, my lord, coming up before your lordship with the plea that my interest is being affected by reason of all these proceedings. I still want to stay outside it. I am not, my lord, interested in the winding up. Therefore, what my learned friend is submitting before Lordship, Mr. Sancheti is submitting before Lordship, perhaps it will not be necessary insofar as my application is concerned to. They will have to take independent proceedings. What is happening is this. What they are saying is this, that this particular property which ICICI Bank has obtained, is it by way of a fraudulent preference? That is the allegation. Now, if it is so, then they have got a right to proceed in by way of, my lord, under the Companies Act against that particular property. But they will not be able to proceed against the property because the property which was sold to me, which I have obtained by way of sale, which has been, my lord, confirmed by the Supreme Court, is, my lord, under the SUVRA Act. And SUVRA Act provision is completely independent of the Companies Act. Supreme Court has said in no uncertain terms that once the SUVRA proceedings take place, then, my lord, Company Court, my lord, says, my lord, touch me not.
My lord, may I intervene? My learned senior.
My lord, may I?
Issues on that. Basically, whether the document which created charge in respect of the bank, whether that document was properly or not, whether the document had sanction of the court or sanction of the law, that is somewhere where if those documents.
You will have to take independent proceedings.
That is for the company court to decide, isn't it? Not this court.
For the company court.
That's what I primarily.
Just have 1 minute of audience, my lord.
Move before the company
Yes.
for an expedition disposal.
Yes, in terms of,
That solves the entire problem, the entire
yes.
issue.
Yes, Malad. If it is decided
So,
by the
Malad,
company
once
court, it
Malad-
is once and for all. Malad, it can be decided.
Forum is,
Yes.
the primary determination has to be made by the company court as to the validity of the transfer from Dunlop to ICICI Bank, whom my learned senior friend represents. My lord, my learned senior friend talks about not being able to assail the SUVRA proceedings. Here, the issue is not about SUVRA, that is a subsequent. But if the mortgage itself could not have been created, then there could not have been any SUVRA.
This is the point.
So this is the point.
May I make a
First,
submission?
This issue has to be first determined. This is a finding of fact which has to be first determined by the company court. Your lordship sitting in division bench will not adjudicate an issue of fact for the first time. This is the submission, and I, as a contributory, have taken out my application for leave to intervene because as a contributory, my lord, I wear two hats, my lord, both as a contributory and as a creditor. But as a contributory, my lord, I am interested to protect the assets of the company.
Can his application for intervention be allowed? Do you have any objection to it?
He cannot possibly have any objection.
Contributory, Malad, this is a dispute, Malad, with regard to the company in liquidation. The company had fraudulently, the bank had fraudulently sold one of the properties of the company. The contributory, the contributory doesn't have any say here. Well, at least in this appeal.
May I just say this much, my lord? May I be permitted to say this, my lord?
This is what my lord taking exception. I am submitting to your lordship by banding about the term fraud. My lord does not make it a fraud. If one wants to allege fraud, my lord, it has to be alleged and it will have to be averred with full particulars. This proceeding before your lordship is not one such. This has to be, my lord, independently argued, independently, my lord, adverted to before the proper forum. This is, my respectful submission is Mr. Thakkar's client is not entitled to intervene in this. He has made an application. My lord, let him move the application. I am contesting that application. I am saying that he is not a contributory. It has been so held by the division bench, not once, twice. My lord, my learned friend, I must say, my lord, absolutely like my lord, the Robert Bruce. The one after the other, how many attempts my learned friend's client has made for the purpose of, my lord, putting his nose in, my lord, I do not know. And every time he has been, my lord, shunted out.
We will hear it out. Please come back with your affidavit.
My lord, I have my affidavit. May I file it? I have served it on Mr. Mitro's land as well. May this be, yes, my lord, may this be taken out.
But may I serve my affidavit? My lord, may I serve my affidavit? I'm a bit out of time, my lord. I'm affirming it today, my lord. I'm for Bhartiya Hotels, my lord.
You're appearing for?
Bhartiya Hotels, my lord.
One. Yes. You're ready with
My
your
lord, my lord, it's going to be affirmed today, my lord. With humility, I say this, my lord. My applicant record is there, my lord, in court.
Very well, very well.
And I have broken my leg, but I'm sorry, my lord, I could not be here, lordship.
Get well soon. We would all love to see you in court again.
I'm
Very
very grateful,
soon.
dear lordship. My lord. Only, my lord, the point of maintainability I have taken against Mr. Mitro's client, my lord, that be kept open, my lord. That be kept open because, my lord, the prayer is not for leave of your lordship's court. The prayer is for recalling. Such an application is barred by limitation, my lord. It cannot be taken up by your lordship at this moment. He needs to take some curative measures to do that. My lord, recalling cannot be made after a period of 3 years, my lord. And he has not sought for leave.
We are not addressing your lordship on the merits, my lord. Let the affidavits be
So, my
complete.
lord, yes, if he is being added, my lord, let him be subject to the maintainability of the petition also. I am grateful.
Affidavit in opposition submitted on behalf of the appellant is taken on record. Paragraph, learned counsel for the first respondent seeks extension of time to use the affidavit in opposition as sought. When can you come back?
My lord, my affidavit I have filed.
I'll serve today.
Another week for you?
My lord, I'll serve by tomorrow, my lord. My affidavit is ready, my lord, so I'll serve by tomorrow.
So let there be a date. Please exchange your affidavits and replies.
Well, I shall file my reply. Well, since they are filing the affidavit in opposition, my learned friend is doing so. I
Yes.
shall file reply to that within any time your lordship fixes. We shall be able to do it.
Your lordship gives a direction, affidavits to be completed in all matters before the next date, my lord, because I am out of time to
Next
file.
date was today, yes.
My lord, before in the next date, my lord. Kindly extend it.
When will you come back? 7th March.
As you like.
My lord.
Grateful.
Let the matter appear under the same date on 7th March 2024.
My lord, kindly,
Affidavits be exchanged in the meantime.
my lord, my learned junior, my lord, who is leading me in the matter, my lord, he won't be here on the 7th. My lord,
Also, my lord, on the 29th, I'm so sorry, my lord, 29th of February.
29th? Will you complete your affidavits by then?
Yes.
affidavits will come.
Special year, my lord, so 29th February. Would it be my lord's pleasure? Leave here, return.
Would it be my lord's pleasure to request for direction upon the appellant and the applicant to serve a copy on to?
Not now.
Not now.
Record as
No, absolutely not.
Intervention point. And their whole sister concern, they all know.
Whatever you say is applicable before the company court, not before this court. So far as my
That's okay.
knowledge.
Nobody will be allowed to.
It is a matter in rem before the company court, right?
Why not anything arises out of a trial court? When it comes before the appellate court, it's a continuation of the.
But if Mr. Sancheti comes in now, I am expecting 5 others will come next day. Then, my lord, they will ask for intervention. On the next day, another 5.
That's
Things will come.
I said the easier mode would be
Company
to
court.
appear before the company
Yes.
court and
Company
request
court,
for-
my lord, my learned friend will do. I am not interested in the company court. Yes, my lord, I am not interested in the company court.
still disposal of the
But
application of the company.
then, my lord, I only want. No, my lord, I only request your lord. No, I only request your lordship, my lord, to kindly consider this, that once a division bench interim order is there, to what extent I will be able to persuade the learned company just to, my lord, vacate it. I will have to come.
To be heard out.
Yes.
Oh, you are now admitting that it is not a final proceeding.
The final
Just now you
proceeding
said.
before the company board.
Just now.
My lord, may my affidavit be
We
taken
should
on?
have it heard before your lordship.
It's not very much on merits. I was just going through it. It's only so that the rights are not affected till the disposal.
Yes, my lord.
My lord,
Yes.
I will-
That's for protection of the properties
My lord,
of the
after-
company, nothing
After
else.
this interim order was passed, thereafter a lot of water has flown down the Ganges. I shall indicate to your lordship what are the proceedings which have taken place. Supreme Court has passed, my lord, at least 3 orders in my client's favor, in pursuance of which this property was sold to me. It was, my lord, put up my lord, all these issues, well, kindly, my lord, give me, my lord,
One other thing, my lord,
My
property
affidavit
I
will be
was
taken
sold to Mr. Mishra's client. It is my property, my lord.
Grateful, my lord. Deeply obliged.
My lord, may my affidavit be taken on record? My lord, lordship will kindly observe that in the order. My lord, yes, my lord, very well, my lord, grateful. Grateful.
तो प्रत्येक दिन आगे उनका ऐड
रोज लोग इंटरव्यू
Original side, single bench, item number 1, the Ni Birbhum Coal Company.
Unconditional apology, my lord. The advocate and record is totally bedridden. Have got
You need some time?
Yes, my lord.
Have you served?
My lord, I am for the petition.
Yes. Service is over. Who is appearing for the respondents?
Respondent ki appeal kachira. Respondent appear, my lord, on behalf of the respondent.
Several adjournments.
But my lord, that is the difficulty, my lord. Only last time, my lord, we have be able to contact this my lord, who is totally bedridden, my lord, Mr. Jain Manna, after the operation of bypass surgery.
Very good. Mr. Dhar is appearing. Mr. Dhar, Mr. Sinha, I do not find any of them. None appears for the respondents. Paragraph on prayer of the petitioner, the matter is adjourned. Paragraph let the matter appear. Shall I place it in the monthly list of March?
Yes. Yes.
As and when you are ready, mention.
Yes, yes.
Well, let the matter appear under the same heading in the monthly list of March 2024.
Naam tak.
Oil mix. Oil mix for the petition. Oil mix. AYNMIT. Grateful.
Item number 2, SS Natural Resources.
Highly thought.
Only for the purpose of pilot. Only one we are unoriginal on this. So he has nice black stitches, pilot, and just get his stick and
I hand over my reports of submissions. It's the size of another writ petition.
no, my lord, I think they have annexed
judgment which my lord.
Well, that will help me. Thank you.
Yes, lakhs of both judgments are already there. Firstly, we just their content.
Lordship, we have annexed another order in the notes. I'm handing over a copy to my learned friend.
If I next it here?
Yeah, there's a new judgment that has been annexed in this. An order of the division bench of this court.
This division bench order?
Lordship.
There. Order sheet টা দাও।
Order sheet. After charging a fees.
Written notes of argument submitted on behalf of the parties are taken on record. Paragraph judgment reserved. CAB.
Grateful.
Portion ভেতরে দিয়ে দিও পুরোটা। Yes.
I will hand it to the lordship.
Yes, yes. Mr. SUVRA এটা দিলে তারপর ওটা দিয়ে এগুলো দিয়ে ফাইলটা দিতে পারে।
It is of submission stitch করে।
উনি একটু পরে দিন। ওয়েট করো উনি দিলে ওটা ভেতরে